All right, let's call this meeting back to order. Welcome back. Intelligence governance and data privacy. I don't think we need to call the roll. We called that yesterday, so we're in good shape there. We've got our quorum. And with that, let's dive into our discussion about artificial intelligence governance. And we've got some bill drafts that we put together. The first couple of bill drafts, I think, we'll go over together. And they're both on synthetic media, which is basically the concept of looking at deep fake legislation and what we can do to potentially prevent fraud in those spaces. We had a good discussion on potential AI considerations and concerns at our last meeting. And we'll have these two bill drafts. Mr. Co-Chairman, before we get started on that, anything you want to add this morning?
No, thank you, Mr. Co-Chairman. I think you pretty much covered it. I think we had some really interesting discussion in our working groups. Certainly, I think our intent between our discussion at the last committee hearing and as well as with the working groups is how do we have basic protections to try to skate where the puck's going to be, but also not being too heavy-handed. And I think these generally do that, but I think it's going to be a really good discussion. I'm sure we'll get lots of, I know the room's not particularly packed this morning, but I'm sure online we'll get some good chatter. So I'm looking forward to it. And I really appreciate, Mr. Co-Chairman, all the work that you've put in these working groups, teeing it up, and just adding that thoughtful discussion. So thank you.
Great. Committee, any comments before we get going? Yeah, Mr. Kaufman, go ahead.
Just a quick introduction, Mr. Chairman, for all of your benefit. You might remember back in, was it May in Jackson, when Mr. Lupien filled in that my firm had hosted 3 interns this summer that were funded by Ripple Foundation.
Mm-hmm.
One of them, Mr. Jacob Lero, who's a UW law student, is here with us. So Jacob's just finishing up his last week as an intern with our office.
Great.
But just want to report it was a smashing success. We loved having these students, and it worked out really well. So just want to introduce Jacob.
Excellent. Welcome, Jacob. All right, with that, Mr. Hopkinson, you want to come up and walk us through our 2 unlawful synthetic media bill drafts. And for the public and for those interested, we're going to take these 2 bill drafts together, then we'll do public comment, have some discussion on those 2 bill drafts, and then we'll switch over to the Artificial Intelligence Foundation model registration, work through that, and then get public comment on that. So we'll have 2 opportunities for public comment. Go ahead, Hopkinson.
Thank you, Mr. Chairman. David Hopkinson with the Legislative Service Office, walking through 24 LSO 236 and that subsequent to that 24 LSO 237, both working drafts 0.3. A couple of things before I dive in. Although there is not a staff comment, that was more due in part to kind of the timing on when these bills were completed and things of that nature. So there are certainly a lot of considerations for the committee with these drafts. And a lot of the terms, I think there's substantial room for improvement. And so I'm going to highlight a few things for the committee as they consider how to proceed with these drafts and look at public comment and things of that nature.
Thank you. And I think it's important to know we for all of the bill drafts that we're working today, there's really no intent to take final action on them. We would have our discussion, contemplate any changes, revisions, what we want to do, and then look to the November meeting. If we're going to take final action on that, that's when we'd be doing them. Fortunately, I don't think any of these things have to be kicked over to the Minerals Committee, Mr. Co-Chairman. So we can do that ourselves in November if we see fit. Go ahead, David.
Thank you, Mr. Chairman. And unless we decide to move these to Title 13,
right,
we should be all right. If the committee wants both a civil and criminal action, certainly it's the committee's to decide on that. If one option, as right now, the criminal bill is in Title 6, which is the general criminal statutes. The civil bill is in Title 40. It may make sense if the preference is to do both, to put both. Something to consider. So first draft 236 creates in 66106 a new section 106. First up, we see the definitions, and there for purposes of this section, the first one is synthetic media, which means any video or voice recording that has been fully or partially generated by algorithms and appears to be a record of actual events. Next is the criminal portion. Subsection B provides that a person is guilty of unlawful distribution of misleading synthetic media if he knowingly and intentionally distributes or makes publicly available within the state of Wyoming synthetic media purported to be of or by a natural person. And then there's 3 additional elements down there: without the consent of the natural person, without constantly displaying an obvious notice within the synthetic media identifying the media as synthetic media, and with the intent to mislead others about the acts of the natural person. Subsection C provides that unlawful distribution of synthetic media is a misdemeanor, punishable by imprisonment for not more than 6 months, a fine of not more than $750, or both. Now, a couple of things I want to highlight for the community. Frankly, a number of potential ways to tackle this particular issue or concern with misleading deep fakes. But one possibility or something to consider is should this be broader, or should a draft be considered that's broader than just limited to things? Committee could consider whether or how to combine the two, civil versus criminal, or are they both necessary? Committee could consider, should it be limited to a natural person? Is that the primary concern? Should it include businesses or corporations that misleading synthetic media might be created about? The notice that should meet that. One option or consideration as far as the criminal side, to simplify it potentially, is simply to make that notice requirement kind of the trigger point. If there's not a notice, it's illegal. If there is a notice, it's not. And instead criminalize the act of failing to provide notice. The one thing in particular for the committee to be aware of and to kind of keep an eye on as you debate the specifics of these definitions and the manner in which they will be employed is, be cognizant of the potential for First Amendment implications. And we want to make sure as best we can that this is, as narrowly tailored as possible to accomplish the purposes of the draft, so that we're not covering speech that is protected by the First Amendment. And they're also, with these definitions, there is the potential to be over or under inclusive and a great potential to encompass things that perhaps aren't intended. With that, and those additional considerations, I would stand for questions on 236.
Committee, any questions on 236? And we can certainly have the general discussion after we go through 237. If we on these, so Mr. Co-Chairman, go ahead.
Thank you, Mr. Co-Chairman. I know we debated this quite a bit in our working groups, and I think, as Mr. Hopkinson pointed out, there's definitely some gray area in there that we need to be careful of. I guess my question, Mr. Hopkinson, is to what extent, I guess, is there any conflict with some of the name, image, and likeness regulations and laws that exist at the federal level? Because I think those, for example, if I'm a celebrity and you want to use my photo, or if I'm a singer and you want to use sample from my music or that kind of stuff. Are there any potential implications or any conflict with some of those federal regs? Do you know off the top of your head, Mr. Hopkinson?
Mr. Chairman, off the top of my head, I can't cite a specific. But I'm certainly happy to dive into that as the committee proceeds with these drafts and make sure that we're in the clear on that front.
Great. Committee, any other questions or discussion before we kind of look at the next bill and then we'll have a broader discussion? Okay. With that, go ahead, Mr. Hopkinson.
In 237, the first part of the bill is the only difference that we see is kind of the enforcement, and that starts on page 3 in subsection C. And that provides that any person who is the subject of or who is misled by synthetic media may maintain a civil action to enjoin or restrain the distribution of the synthetic media, and may in the same action seek damages from the person who distributed the synthetic media. The court may award any of the following remedies to a plaintiff prevailing in an action: equitable relief, damages, costs and fees, including attorney's fees, and exemplary damages in an amount not less than $1,000 per plaintiff. D and E provide for the Attorney General to enforce the article and investigate violations of this article, and that they may bring on behalf of the state an action for temporary or permanent injunctive relief in a court of competent jurisdiction for any violation of the article. And they may, upon entry of final judgment, award restitution when appropriate to any person suffering loss from a violation of this article if proof of loss is submitted to the satisfaction of the court. Subsection F then provides that the article is not the exclusive remedy, that other statutory or common law provisions against conduct or practices similar to this, what's in this bill, that those remedies may still be available to the person, but the specific remedies in this bill are exclusive to this bill or to this act. So some additional considerations then for the committee, of course, is particularly in paragraph 4 on page 3, the exemplary damages is that requires the same things as far as that the act has to be without the consent of the natural person, without the notice displaying, and with the intent to mislead others about the actions of that natural person. And with that, I would stand for any questions on this bill.
Chairman, Mr. Hopkinson, on line 1, page 4. Or excuse me, line 1, page 3, like that. At the end of the sentence, it says misled. Obviously, I know what that means. You know what that means. We all broadly know what that means. But in terms of the court of law and civil litigation, what does that threshold look like? Do I just have to say, I think I've been misled? Or could you elaborate on that, please?
Certainly, Mr. Chairman, I think as drafted, and we could absolutely include in there something more specific, a baseline for what it means to be misled, but otherwise it would ultimately be up to a jury or to the judge to determine if it's kind of met a threshold that you were actually misled.
Our good litigators on this committee have to say.
So I'm going to be honest, I was thinking about the damages. Can you repeat that question? Because I've got a separate question, Mr. Chairman.
No, I guess, Mr. Coffin, my question to Mr. Hopkinson, I guess the committee at large is when it talks about right there in paragraph C on top of page 3 is misled. We all know what that means broadly, culturally speaking, but in the court of law and civil litigation, what would that threshold look like? And I guess the question is, do we want to leave that up to a judge or to a jury of our peers?
Is there another comment? See your Go ahead, Senator Nethercutt.
So I think, I mean, generally speaking, a jury instruction would be provided based on definitions associated with what misled means. I think the greater concern here is the class of potential plaintiffs of who claims they are misled. So what I envision happening here is someone creating synthetic media, pushing it out on social media, and then a number of people, thousands, if not more, view it and are quote unquote misled, who then could not sue. And maybe that's the deterrent, that you could have the class of plaintiffs that include the entire state of Wyoming seeking damages for being misled about a political candidate, for example. So, I mean, that's a concern. But so what does it mean to be misled? You know, what a reasonable person would be misled under the circumstances. I think certainly it's an area for interpretation, but that's what juries are for.
Go ahead. Mr. Kaufman.
Yeah, so Mr. Chairman, the reason a moment ago, what I was looking at is, and maybe this isn't the right road to go down, but my brain goes down the Trade Secret Act road, because there are so many analogies here to what's already in the Trade Secret Act, and the Trade Secret Act defines it as misappropriation, right? And that can happen just as a matter of fact. You disclose something that you don't know have right intellectual property rights to disclose, just by virtue of the fact of you doing that, right, can result in liability. So it's not so much this subjective analysis of we have a whole plethora of law out there about parody, right, with respect to
Yeah.
what you can and can't do with someone's name, image, or likeness with respect to, you know, parody like representations. I mean, that's not easy to define. We have Supreme Court cases that have tried to find that line. So I don't know if mislead is the right term, but what I just wanted to highlight for the committee is I think that we should look at the Trade Secret Act in conjunction with this, because there's a whole number of damages that are laid out in the Trade Secret Act, but also this idea of just misappropriation in general, right? As opposed to getting at the intent. It's more of an objective analysis of did it happen, did it not, right? And then what was the depiction from there? So that's not a complete analysis by any stretch, but I think it makes a lot more sense maybe to look at that as an analogy.
Go ahead, Mr. Co-Chairman.
Thank you, Mr. Co-Chairman. Mr. Comment, I think that's a great point. Just our parody law is expansive. You know, there are certain TV shows that are cartoon that were started in Colorado by a pair of brothers that just opened up a restaurant that have actually, you know, stretched that parody law quite a bit and really pushing it to its limits. And so I guess my follow-up question would be, I make a deep fake. I say, well, judge, this is parody. This is not to be taken seriously. You know, would that, you know, nullify or greatly, you know, defang this type of legislation? And I guess in terms of the trade secrecy stuff, I'm not familiar with the act, but do individuals, because I assume that was designed more for corporations and companies, but do individuals have standing in that
Yeah,
that act?
Mr. Kaufman, go ahead.
Mr. Chairman, they do have. Said you can have a cause of action by virtue of somebody acquiring something in an inappropriate manner, or somebody distributing something or revealing something in an inappropriate manner that they don't own, right? Because you have title or claim to that ID or that intellectual property that might not be registered. The reason I think that that's important maybe to look at here is what you were just describing, right? If I take Mr. Hopkinson, do we really want to go down the road of am I intentionally misleading people, right? Or are we jumping to something like a misappropriation analysis to what's the harm? You know, what are the damages? Is it parody, or is there some parody like analysis for this? So again, I don't have all the answers. This isn't necessarily an area of expertise for me, but we have a lot of law existing that creates both equitable damages or I'm sorry, equitable relief, but also damages that you can seek for relief based on slightly more objective tests. What? Slightly, arguably more objective tests. I don't know how to phrase it, but
Yeah, go ahead. Let's go to anything additional before we move on. All right, let's go down here. Representative Singh.
I'd like. There's a blatant statement in the episode that says this is a depiction. And that's clearly laid out. And in this legislation, that would not be the case. That's not what we're addressing. If something is explicitly stated.
And Representative Singh, along those lines, also, when we look back in both bill drafts to the definition of synthetic media, the last clause on lines 6 and 7, page 2, appears to be a record of actual events, which is kind of a key concept of misleading. I don't think anyone would confuse South Park with a record of actual events. Although a lot of times it might be spot on, it still wouldn't directly be confused. And obviously the danger here is not through parody, satire, First Amendment, opinion, anything along those lines. The danger that we're trying to contemplate is a circumstance where the purpose is to intentionally mislead about whether it's an individual's false message or something that appears to depict true events that are intentionally misleading. So I think we know what we're targeting, but getting it right so that we don't end up running into protected speech and the areas that we want to continue to protect and keep preserved it becomes a challenge. Go ahead, Representative Andrew, and then I saw Senator Furphy's hand.
Thank you, Mr. Chairman. I guess this is a question for the working group, but I'm just wondering why we're putting this in Title 40 and relating it to consumer protection. And was it considered to put it in Title 1 and relate it to libel? Because that's what, in my mind, I consider it probably a form of very modern libel instead of a consumer protection issue.
So it can be libel, but one thing that was discussed and it gets to a little bit on page 2, line 15, without the consent of the natural person, which is a requirement in both of these bills, but is a discussion point. You can have consent of the natural person and still be misled. You can imagine a historically inaccurate, favorable depiction of somebody that didn't happen, right? Where I look back into the ocean, right? That was very heroic of me. It didn't happen, right? It couldn't have happened, but
We want it to happen.
right, we want it to happen, and obviously I would try. No question. If I was there, I'd do my best to get that whale back into the ocean. That's still misleading, but it would be something that perhaps I could arrange that would be favorable. So it's not libelous at that point. It's just intentionally misleading. So it's misrepresenting facts to mislead the public in a way that will skew perception of reality. So that's not libelous, but what is that? And that's actually a little bit different from anything else that we typically deal with. But it can be just as damaging if done well. We can all think of circumstances where that might be incredibly damaging to the public. As drafted, I don't think that scenario would qualify under the B paragraph, because if I have consent of the natural person, I think I immediately obviate the B paragraph. I'd ask Mr. Hopkinson, is that accurate? I think
And if there was consent, then it doesn't matter if it's misleading.
Yeah. So that's something to consider, and that's one of the reasons why I don't know that it quite gets to libel, but that doesn't mean this addresses it. And with that, maybe more discussion on Representative Andrews' question. Mr. Hopkinson, do you have any thoughts on libel statute versus consumer protection statute for civil remedy?
Mr. Chairman, no, that's certainly, I think, something that could work either way. I think one of the reasons I was looking primarily at Title 40 was in consideration of potentially combining the two drafts. There are other laws in Title 40 that include criminal as well as civil penalties. There's some language in there that kind of ties into what this draft does. And I was kind of looking at it from what's this for? Well, it kind of fits with consumer protection. We're wanting to protect people from being misled in that sense.
Yeah.
So, but is there any particular magic to Title 40 versus a Title I determination? I don't think so.
Great, thanks. Go ahead, follow up there, and then I'll go to Mr. Coppin wants to follow up as well.
Thank you, Mr. Chairman. I guess that's just it's kind of a policy question for the committee to explore, is like, are we trying to protect people from being misled, or are we trying to protect the victim in the situation? And my mind has always been with protecting the victim, and I think that's something we need to discuss more on which way we want to go, because I see it potentially being problematic with protecting people from being misled, and potentially even some First Amendment issues there. So thank you.
So one comment I'll respond on that is the greater potential for damage in the near term is probably people being misled. And I say that because we're probably realistically not worried about Wyoming citizens being deep faked in the next few years so much as Wyoming citizens being misled dramatically in the next few years. With the exception perhaps of my attorney. So both sides realistically need to be protected, and that was part of the discussion. If you have national policymakers perhaps running for office and deep fakes are deployed in those circumstances, which is probably most likely next use case, right? First use case, first significant use case. They're not going to utilize Wyoming statute as a way of protecting themselves. They're not going to come to Wyoming and say, well, we'd like to make use of this law. But the victims, so to speak, of the act would include Wyoming citizens that should then have standing and some type of redress, which is the purpose of the way that this is structured, to allow it to be both ways. Now, clearly, if you are somebody that is victimized by somebody creating a deep fake of you, Representative Andrew, you would want still to have that standing. And I think these are both structured so that that's clear and direct, that you'd have that. You already to some degree have some protections on that realistically, but this would improve those. What are your thoughts?
Thank you, Mr. For the next meeting.
Yep, sounds good. Mr. Kaufman.
Mr. Chairman, I can hold off. I've got some other random topics, but I can wait.
Different ones,
No,
okay.
yeah.
So on that point, anything else on that point at this time?
No, the only thing I was going to say regarding the location is, again, Title 40 to me makes sense. That's where the Trade Secret Act is and
Okay.
some of our other IP-like protections in Wyoming. So well taken points with respect to the libel, but to me, it makes sense where it's at.
And if we were to do name, image, likeness work, which we've talked a lot about, it would probably end up in Title 40 as well, which relates. I mean, it's not exactly the same, but it certainly gets into the same realm as what we're talking about here. Senator Furphy.
Thank you, Mr. Chairman. Yes, I'm big on protecting the victims. And it's already happening in our state. People being misled by supposedly corporations that they're working with their computer, et cetera. I've had constituents contact me. They've lost thousands of dollars already by misleading information. Now, you try to track these criminals, it's impossible. So I don't know how we get to the criminals, but we've got to get to the criminals, and we've got to protect members of our citizens of our state that are being victimized by this, not just being misled in a campaign, et cetera, but are losing true dollars out there. So I just wanted to make that point, Mr. Chairman. Thank you.
Thank you, Senator Furphy. I see Mr. Pope has his hand up online. Let's go to.
Thank you, Mr. Chairman. Can everyone hear me okay? Mr. Chairman, can everyone hear me okay?
Here we go. Gotcha now.
Okay, thanks. I come at this from two perspectives. First off, in 2019, I was the subject of a high-tech based attack, solely because I was a member of a board of a local nonprofit, and an international supposed nonprofit decided that we were doing the wrong thing, and it doesn't fit this circumstance, but I have seen the power of malicious use of technology. So, and my first comment is, whatever the damages are, they're not enough whatever the exemplary damages, whatever, it's just not enough. We need the ability to be protected. The second thing, perspective I come at this from is from a litigation consultant, and I've calculated damages in a number of cases. And my only real comment on this is, misled, I think, is really, I think somehow we have to get to a cause and effect, a cause and a material effect, and something to the tune of it causes the misleading material causes the person to take an action that a reasonable person normally would not have taken. It restricts it somewhat, but it also creates parameters around it, so that just being misled and going through that thought process may not rise to the level of the exemplary damages. So it causes you to not vote for a person. It causes you to choose a different product. It causes you, there has to be cause and effect built into this. Otherwise, Senator Nethercott is right. You could have the whole state of Wyoming filing lawsuit. So those are just my 2 cents worth of input.
Thank you, Mr. Pope. Any follow-up on Mr. Pope's comments or thoughts on that? Discussing a standard, a threshold, something along those lines for what it means to be misled, what level we go to. That's a good point to contemplate. Senator Nethercott, go ahead.
Mr. Chairman, I think Mr. Pope is correct in that line of thinking, to just, it's implied, I think, that if you have been misled, you believed what you were provided and you likely acted on it, but it's not in the statute. So I do to place that isn't too high. This does connect to libel I mean, in the sense that Representative Ocean was mentioning, these are all kind of coincide with each other. And the standard associated with libel, right, is very high, where you have to prove damages typically, with some exceptions. And that can be very hard to do, that you've been economically damaged because someone made false statements about you. So it makes it a pretty unworkable tort for relief. And I like what Mr. Pope is recommending, which is not that high of a standard, but a threshold to, you actually have to have been affected by the misleading information, but it doesn't require you actually to be potentially financially damaged as a result of that, based on the available damages that are listed. It could be exemplary damages as well.
So how would that play out? Then that would be a circumstance where you would have some type of class action. You'd have 100 people that were saying that they were misled, and then they would come in and indicate that they changed their behavior in some way. They did something differently than they otherwise would have because of the misleading information. And then that would be subject to scrutiny by the jury in the court. Is that your contemplation, Senator?
Yes, I think it's the proximate cause, right?
Okay.
That caused the harm.
That's it, yeah. Senator, I think that's a kind of a nice bit of phrasing that maybe we want to
I created it.
include. Yeah, I know. First time anyone's ever said proximate cause, just then, Senator Nethercutt created that. Yeah,
It's-
copyright that. It's not anywhere else.
It's all over the law. Just a disclaimer there before you feel misled.
Oh, so that was a misleading representation of events. All right. Any further thoughts on that, Mr. Pope? Following that conversation, it seems like a appropriate approach here.
Mr. Chairman, thank you. I agree. I do believe there has to be some parameters, how, light parameters to be sure, but still some parameters around how to proceed in this type of action. So thank you.
Great, thank you. Further discussion on that point, or we can go to another point, but go ahead, Representative Singh.
Just a thought. The media that you consume, if you're assuming that this is digitally created, right? So you're watching it as a video or some sort of media clip. This media has been assigned to you by a social media algorithm operating on a totally different scale. That isn't where it was generated per se. So even if someone were to by chance associate with a particular tag that they didn't realize was on a video, and then they clicked on another tag, and then all of a sudden the algorithm is feeding them this type of video. Maybe there's responsibility on the part of the provider of that algorithm itself. How does that relationship fit in?
So, Mr. Hopkinson, yeah, exactly. As I read this, you have to have the intent. It has to be willful intent to mislead. If you're the intermediary that distributes, so you're the social media platform, and you have a passive role, you wouldn't qualify for any of this language because you did not have the intent to mislead, unless somehow you got involved on the intent side. I mean, theoretically, you could be early in this and be intending to distribute. But at that point, let's see, if you weren't the generator, would you? Go ahead, Mr. Co-Chairman.
Thank you, Mr. Chairman. Along those lines, I certainly appreciate that they're an important facilitator in that specific example. I'm pretty sure for our libel, that does exempt those types of platforms. Kind of in the abetting and the distribution component. So I think it was originally intended for radio and for those traditional mediums versus the modern social media platforms, but that's something to consider.
But yeah, Mr. Chairman, if you look at the language on page 2, either draft, lines 10 on to 12. When he knowingly and intentionally distributes or makes publicly available synthetic media purported to be, et cetera. So you have to have knowingly and intentionally distributes, and then it has to meet those standards.
It says or.
He knowingly and intentionally distributes or makes publicly available. So the knowingly and intentionally modifies, distributes, or makes publicly available, right? I think it's intended to. If I read that as intended to, if you read it differently, we probably need to fix it.
So I would read it this way. A person engages in distribution of misleading synthetic media unlawful under this article when he makes publicly available synthetic media purported to be of or by a natural person. So I think Representative Singh's concerns are relevant here because of that or and how intentionally distributes and makes publicly available. It's an or. And so that or is really a significant
I
word.
think I disagree, but I think it's still worth fixing. Go ahead.
Thank you, Mr.
Hopkinson.
Chairman. And certainly the intent is to have that knowingly, intentionally modify both the distributes and makes publicly available. So we can clarify and make sure that that comports.
Yeah.
So that that is the intent, or that, so that that is accomplished, because it is intended to be knowingly and intentionally makes publicly available within the state of Wyoming. Or whether they, so, yeah, the knowingly and intentionally is intended to apply to both distributes and make publicly available. However, well, I guess I'll stop there.
Yes.
It.
And if anybody were to interpret it the other way, yeah, that would be be challenging. What's the difference between distribute and make publicly available that we would have to have distributes instead of makes publicly available? I mean, that seems to be the key threshold. I could distribute a deep fake, but it's the publicly available that seems to be the problem. Maybe.
I think if I put it up on out my own website, that's making publicly available. But if I push it out, that's distributes, like on social media.
Yeah. So we probably want both and we need to modify it. Okay.
Well, and Mr.
Sure.
Chairman, that at least as drafted, it's intended, I think. Even just the distributes would apply to if you email it to your best friend. That could potentially apply to this. He didn't necessarily make it publicly or widely publicly attributed it to another person.
Yeah, we'll have to give that some thought also. Go ahead, Mr. Co-Chairman.
Yeah, Mr. Co-Chairman, I would say that the or doesn't necessarily clearly bifurcate and make one null and void over the other. I mean, if you do one of these, you're guilty, but also if you do the other publicly available component, whether you email it to a friend or whether you put it out on social media, I think it doesn't necessarily, one doesn't nullify the other as I read it.
Okay. Mr. Pope, you have your hand up. I don't know if that's a new hand up or if you just left your hand up.
It is new. I'm yes. Okay, so I think also looking upstream from the video, it may be, we may want to consider adding or assists in the making of the video in order to answer the concern of the algorithm being provided to someone that then finishes it and then distributes. Who carries the liability here? Really, I believe that you should be able to net the net or create a net that provides liability to everyone in the stream.
Thank you, Mr. Pope. Thoughts on that? The one concern I have is the key consideration needs to be the intent and knowingly with the, intent to mislead concept. But you can imagine a circumstance where somebody is making a deep fake without the intent to mislead. They're playing around with software and then somebody gets that. And then ends up being the distributor of it because they think it would be a great way to mislead. Do you then loop in the individual that was just working with some deepfake software since they didn't have the intent, and how do you draw that line? And I think in a circumstance where you have multiple individuals in that chain that have intent, Mr. Hopkinson, what do you think?
Thank you, Mr. Chairman. I think that as drafted, anybody who is part of either distributing or making that publicly available and does so with the intent to mislead, I think it would apply to them. So if you're looking at, the entity that is just making it available on their platform, for example, do they have the intent to mislead? I think that would be their potential cover there, but certainly, I mean, they may have some concern, or I guess I could anticipate down the road, somebody making a claim that the platform itself had the intent to mislead, and then there's a lawsuit based on our law on that. So that's certainly something for the committee to think about. But I would agree that as drafted, whether you're the person who mislead would potentially be liable.
Great. Go ahead, Mr. Cobb.
Yeah, Mr. Chairman, sorry to keep launching
No,
grenades here,
please.
but I guess, and that makes sense what Mr. Hopkins was just saying, but it kind of called into my mind. The more we talk here, the more broad this seems to be getting, and I mean, I was just rereading the I mean, that should probably be much, much more clearly defined than just algorithms, or we could potentially be talking about any alteration of media, right? Is that what we're really going after here? Or are we really going after kind of the deep fake scenario? So I just raised that question, I guess, for the committee to consider, because if we're really going after the deep fake concern, I think we need to revisit the synthetic media. Create some language around the reference to the algorithm to make that much, much more specific. But I think that's really important in light of what you all are talking about with respect to the misleading nature, right? And the intent behind it, because what we ultimately use as the definition for that synthetic media, I think, is going to determine how wide that net gets cast as to whether or not, right, this media even qualifies under that analysis of, right, the misleading and so on. So I don't know, again, just I'm not sure that I have any answers right now at the moment, but
Thank you. And one consideration on that point is that if we just said something like generated by generative AI algorithms as an example, I guess the concern would be at that point, you could loophole the law by saying, all right, well, we're going to use an algorithm that isn't a generative AI algorithm to develop our deepfake. It's going to take a little longer, but we'll come up with something. And then all of a sudden we're not covering it. So that if we have a specific list of algorithms or detail algorithms more, can you then create a loophole exception where you're not within the law? And I appreciate that point that we want to make sure that we're threading the needle right there. I don't know what the answer is. Go ahead, Mr. Co-Chairman.
Thank you, Mr. Chairman. You kind of piggybacking a bit off Mr. Kaufman's point, the whole intent behind this legislation is to ensure that these new deepfakes that are coming out, audio, visual, and otherwise, are getting better and better, and to protect folks from being the subject of one or being misled by one. I would seem that adding that generative language to this would be beneficial, because of all the deepfakes we're using, pretty much all of them are using some type of generative software, right? Some sort of generative model, at least that I'm aware of.
Thank you, Mr. Co-Chairman. Anything else? Any other overall topics that we want to get to before we go to public comment on these bills? Go ahead, Mr.
Just
Kaufman.
one more, Mr.
Yep.
Chairman, and again, just a question for the group. Most other private IP this bill doesn't currently contemplate a statute of limitations. I don't know if we want to or not, but I just raised the issue.
Good question, Mr. Co-Chairman. Go ahead.
Co-chairman, Mr. Calvin, do you know off the top of your head, what is our statute of limitations? In our
Libel.
civil statutes? We have to-
I think most fraud and like those kinds of statutes are like 2. One year, on 1 year on intentional tort.
Yeah, I believe it's 1 year for an intentional tort, and then there's a default for all other not specifically described, and I think that's 4, but we need to double check.
So. Senator Nakao, we'd end up with 4 years if we wrote nothing is what you.
I
what
don't
you
know that to-
believe. Okay,
I don't know that to be true. We
Gotcha.
need to double check that in the
Okay.
statute.
okay, sounds good. It's a good point to contemplate. I don't know what the right answer is on that, but.
I'll practice rule 101.
Yeah.
Do not
We'll-
guess your statute of limitations deadline.
We'll look into that. All right, anything else before we go to public comment?
Mr. Chairman.
Go ahead, Mr. Hopkinson.
I just did want to kind of highlight. This definition of synthetic media, of course, it is intended in a sense as a lever for the committee to push and pull as far as what's included and what's not. This definition of synthetic media is not something that you would find, as a definition of synthetic media broadly. And when you look at algorithms in particular, and the discussion on, just a generative AI, you'll see some of this in the foundational model bill, but it does become a bit of a challenge. How do you define generative AI? How do you define that sort of thing? And so that's just something the committee will have to consider. And as we maybe end up pushing into another definition, and then you have run into the same problem. How do we define that? But just something for the committee to consider. And I did want to note, just briefly, I would probably change voice on where it says means any video or voice. I'd probably make that audio, just a quick change, but I'll make that later. But
Mr. Chairman,
Go ahead, Senator.
just another concept to consider here, because this topic really dovetails into a lot of other areas of law. It's fairly interesting in that way. But one use of this, I think, is of how it can be utilized in the context of criminal behavior with revenge porn type of behavior, which we passed a bill last year, I think, addressing this. Representative Stitt's bill, I think, addressed this. This applied to those scenarios unless that content had a display on it that said, that disclaimer, but still was using someone's name, image, and likeness in that way. So I'd like us to look at that criminal statute that we passed and see if it covers this scenario or not, or how it plays into it. And here's how that connects to slander and libel, where typically for slander or libel cases, you have to prove damages unless it's related to a specific type of slander or libel. And that can concern allegations concerning moral turpitude and morality, those types of things. And so this certainly would fall into that kind of libel per se situation, arguably, creating that exception. So I think I'm just planting that seed there to discuss later with the committee and Mr. Hopkinson as we look at that previous legislation we passed And then some of those policy considerations associated with those per se exceptions with libel.
Great. Thank you, Senator. Anything on that? All right, let's go to public comment. Let's start with public comment in the room, if we have any, and I know we've got some online. Oh, Mr. Pope, I see your hand up first. I'm sorry. Let's go back to you before we go to public comment.
Thank you, Mr. Chairman. Couple of things. I know that some of my suggestions have may be used to broaden this act, but I don't see any reason why we shouldn't include manually manipulated material in this. Again, from some of my experiences, I have very little sympathy for people who maliciously disseminate materials on that are not true. But then in particular, if you look at line 22 on page 2, it specifically discusses the acts of the natural person. I have an issue with the natural person aspect of it. It can be a business that is attacked and maligned. And so I think that we may want to address that language, and then the acts part of it. It could also lead to or be misleading about the acts, opinions, or associations of a person or a corporation. When you use that language, it does broaden it, but I can see a situation where someone is, I guess for a better word, Photoshop next to Hitler, or speaking to Hitler, or whatever, because that association would be a very, very detrimental association for that person. So I as a non-attorney, I'm trying to figure out how to broaden this, but not to a point where it is an unworkable law. So I'd really like maybe a little discussion from the attorneys on that area.
Thank you, Mr. Pope. Any thoughts? Anyone have anything to add to that? I mean, acts or characteristics, something along those lines of the natural person, basically trying to get at the fact that it might not just be the actions of the natural person. And then with regard to natural person, that is a policy decision. And when we looked at this as a starting point, narrowing it to protecting natural persons and the actions of natural persons rather than corporations was intentional to keep it narrow, because I think you get into a lot more complexity when you're looking at corporations, as well as the fact that you're not depicting typically a corporation in the same way that you're depicting and faking a human, although I guess it's theoretically possible. Mr. Co-Chairman, go ahead, Representative Andrew.
Thank you, Mr. Chairman. I guess if we're bringing it that far, I mean, I think it would be pretty easy to fake a corporation. I mean, maybe you have employees of a corporation doing something particularly illegal and making the corporation look bad. But once you get into this area, I mean, how much of this is already covered by the libel statute? I mean, I guess that's something to consider, because I assume if somebody did what I just described, that corporation could easily sue them for damages and
financial,
monetary
right.
damages.
Yeah, we were talking, some of us yesterday or the day before, about the fact that we actually have better protections for corporations than we do for individuals in a lot of ways. And this is probably one of those circumstances where since you can demonstrate financial damages, you probably have recourse under law in an easier way than you do for an individual. Go ahead, Mr. Co-Chairman.
Thank you, Mr. Co-Chairman. I certainly appreciate Mr. Pope's comments, and they absolutely make sense. But I think they're beyond the scope and the intent of what we're trying to address here, which is the prevalence of deepfakes using generative artificial intelligence to portray and mislead the people targeted and others who view that media. So I think it's a worthy cause, absolutely, but I do think it's outside the scope of what we're focusing on in the intent of this legislation.
Thank you, Mr. Co-Chairman. Any further discussion before we go to public comment? All right. Who in the room, by a show of hands, I'm curious what my numbers are that want to testify on this. Okay, we've got a couple. All right. Come on up. Please introduce yourself to the committee, state your name, and share your thoughts. Welcome.
Thanks. Hi, my name's John Stokes. Been involved in AI for a couple of years. I got involved with the IEEE to help craft the criteria for AI certification. I've been kind of a whisper in y'all's ear to get AI policy crafting, so I'm pretty excited to see this happening. My thoughts on deep fakes or security in general is always a cat and mouse game, and I guess it could be beneficial to look at solutions that could be put in place, like enforcing companies that have streaming services or video platforms to incorporate certain open source penetration testing tools for deepfakes, so that consumers can click a button and see if that content they're viewing is legitimate or not. The definition of sixth generation warfare is utilizing AI to kind of manipulate people's perception of reality. And it's we're biting at the heel of the elephant with this one. So yes, thanks for trying to tackle this. And if y'all have any questions, I'll try to answer what I can.
Great. Thank you so much, Mr. Stokes. Any questions for Mr. Stokes at this time? Yeah, and I think specifically on the point of trying to work with providers, that's something that probably needs some evolution. It needs to happen, but one of the challenges is at this point in time, there's no problem with disseminating the information of deepfakes. So step one needs to be make it very clear that this is behavior that we will not accept, and then a next step. We need to make sure that we're getting them engaged. I was thinking about takedown orders and other things as well. What would the implications of something like this legislation be on having a takedown order request with a provider? Once you issue that takedown based on this, will they feel compelled under this statute to actually issue a takedown and remove the material? Hopefully the answer is yes, but it's a good point that if we don't have that integration and work with them at some point, that we might not get to that point.
And then is there any policy that could be crafted that can protect consumers from corporate espionage or like foreign companies that would disseminate information to try to manufacture consensus to change market sentiment or manufacture consensus for wars or political whatever? I think there's a lot of potential avenues for manipulating people's perceptions, and of course it's been going on for a long time, but now we have the technology that really amplifies and accelerates it and gives that power to anybody really. And I'll give y'all a presentation at the end of this, at the last public comment, and kind of take y'all down a little uncanny valley to kind of see where this paradigm is going. So
great. Thank you, Mr. Stokes. Appreciate it. All right, come on up. Please introduce yourself to the committee and welcome.
Thank you. Thank you for allowing me to speak. I took some notes as I was listening to how you defined a few things. Wiener. So the first thing that I noticed was the difference between distribute versus publicly available. And I think in the context of social media, The most obvious example of this is a private Facebook group where someone has clearly disseminated the information, but the indicator of the tag on the name of the group is private. So they are, by their own estimation, not releasing this to a public, so to speak. It's a small private group, but they have then disseminated the information. So that distinction is important as media companies, or social media specifically, allow us to segregate our audience down further with the moniker of private specifically. The second thing relates to how content is created and monetized. So the conversation that I heard happen and occur based on the legislation proposed takes into account that social media companies previously had not been paying their content creators. There were ways for content creators to monetize their likeness by driving their audience to a different web page or to a different channel, or maybe even to buy a product where they get some sort of referral fee. But in this case, we now have platforms, without naming them specifically, that directly pay. So they directly have a financial incentive in the content created by the creators. And I think if you don't consider that in this legislation now, it's going, by the time the legislation gets passed and enacted, it's going to be behind the ball, because there are at least two of the most major social media companies now that are directly paying their creators and can have this perverse incentive where the thing that is this deep fake is exceptional in the amount of attention that it grabs, because it's lascivious or seemingly out of character. And the content that is created by the malicious actor benefits the platform in views, but then the platform ends up supporting this deep fake or this malicious activity by paying the creator directly who created or disseminated that information. So I do think it's important to understand that the media landscape is changing, these companies are changing, and to see where they're going as we're crafting these legislation. Thank you.
Thank you. Questions, Mr. Co-Chair, go ahead.
Thank you, Mr. Chairman. Zach, so in that scenario that you just described, let me try to walk you through a hypothetical here. Let's say I don't like my co-chair and I have an account on Instagram, YouTube. I create, I put in some input data of him at a radio show or on a TV show, and I feed that into some generative AI of him, and I make it say some mean, nasty things. What you're saying is that should it get enough views that YouTube is automatically just going to drop a check in the mail to me for doing that? Is that a fair understanding?
Not just YouTube, because you do have to become a creator on YouTube, but with some other companies, right? You don't have to register the same way. So YouTube has thresholds where they monitor the content and the quality before allowing you to receive the benefit of the royalty. On at least two other major platforms, the content is not reviewed. There's just, can I pay you? And do I know who to pay taxes to? And that's the only requirement for you to start receiving funds. So while I'm not as concerned about YouTube, there are other media companies, specifically one that we've, as the United States, have been pretty aggressive in taking a look at as it came out of China, that was the first to monetize their creator platform. And we can see that most of the stuff that's monetized right now is not what you would have expected to have been popular before the monetization happened.
Go ahead, Mr. Co-Chairman.
Thank you, Mr. Co-Chairman. You mostly got at what my follow-up was, which is, again, YouTube has a much more vetted process of allowing people to make money off their content. Walk me through TikTok's kind of their process of authorizing people to be eligible to receive money.
Go ahead.
Thank you. It's basically a threshold of, are you worth it to the platform for us to cut you a check? Like, do you have enough views in their algorithm? And do I know where to pay you? Now, there's some other elements there. Are you old enough to get paid? You have to put in your tax ID if you're a business, or your social security number. Potentially, there's at least one platform that you can obfuscate that through something like Plaid or Plaid. But essentially, you don't need to describe anything other than where to be paid and how for them to pay your taxes in order for you to start to profit from this.
Great.
Or protocols if you want to target a US audience and you are a non-US creator. Do you know I know you don't work for TikTok, but you seem like you're knowledgeable enough. Go
So
ahead.
I do believe that they do. I know that they've testified that they're working towards these issues. I'm not convinced that the threat is coming only from the outside of the US. You can imagine that if it were that was engaging, that might end up on traditional media in prime time at 11 p.m. Right. But the idea of this, the monetization for the threshold, it's not limited to social media, and it's not limited to whether or not something has put into place roadblocks to try to deter malicious actors. The problem occurs specifically when the malicious action takes place and the platform ends up paying the creator to create a cycle of profitability for malicious actions, right? So a one-off is a one-off that any malicious actor may try to do to achieve their goals. But the platform creates this feedback cycle of monetization that allows the malicious actor to continue perpetration and essentially be funded for this malicious activity.
Co-chairman follow. Committee, any further questions? Chairman, co-chairman, I think this is a good and interesting point that we need to contemplate is that perverse incentive. I do think that it creates some complexity when you've got a financial motivation instead of an intent to mislead that gets into protected speech in a way that we're trying to avoid. But we need to give some thought to this concept, as well as it gets back to the takedown notice type the millions of clicks on the deep fake. They might take their time on taking that down because it's a fun watch. Go ahead, Mr.
Yeah,
Kaufman.
Mr. Chairman, I sound like a broken record. I keep referring to the Trade Secret Act, but again, to me, this is an interesting analogy because I mean, the libel and slander defamation actions that I'm aware of rely mostly on the damages suffered, right? And the person bringing that action has to prove those damages. Whereas the Trade Secret Act flips that. It says you as the perpetrator, what money did you make off of this, right? And we're going to use that as a basis for how to calculate damages. In fact, and I should have brought it with me, but the Trade Secret Act even has a mechanism in there under the injunction statute where a court has the latitude in the process of ordering their injunction to require that person to pay a royalty, right? For any trailing revenues or profits that they might obtain off of that. So again, I just keep coming back to that because everything we're talking about keeps making my brain go. Like there is some mechanisms that we have that I think we could draw from to make this more useful.
Great, thank you. Senator Nethercott, go ahead.
Mr. Chairman, thank you. To Mr. Kaufman, I think you're right that the Trade Secret Act provides a great framework. And I am not as familiar with it as you are. So what is the dispositive fact there? What sets up how does one become eligible to avail themselves of the Trade Secret Act? That seems to be the distinguishing factor here associated with a local legislator's image being used in a deep fake or anything else, similar to that. That's not trademarked. Right, so I'm assuming it's the process of becoming trademarked that then allows you to avail yourself of that relief. So can you explain that further?
Mr. Kaufman, go ahead.
Yeah, Mr. Chairman. So there's two different things there, Senator. I think there's trademarks, but there's also trade secrets. Trade secrets being competitive, right? Information that is otherwise private, that's just not publicly known. And if someone obtains that, or they wrongfully share it, or they benefit from it, like we're describing, trademark is similar, right? But trademark involves the affirmative action of going and registering this mark or using the mark in commerce so that you have that right from common law usage. So they both have similar remedies available, but how you obtain those property rights is a little different. So here we're just talking about someone's individual image likeness, right? So I think there's analogies that can be drawn for purposes of how do you prove the wrongdoing and how do you create a useful mechanism for obtaining damages or injunctive relief? But it's a different starting product.
Any follow-up, Senator? No. Okay, thank you. Further questions for Mr. Weiner? Seeing none, thank you. Appreciate your time. All right. We have a number of people online, and I know some of them are speaking about this legislation. Some might be signed up for the Bill Draft 239. Who do we have that's going to speak on this one? Looks like Daz is up. Daz, you want to speak on these two, I assume. Is that correct?
Yes, please.
Excellent. Welcome, Daza. Please let us know who you are once again, although we know you, and welcome to the Select Committee once again.
Thank you very much, Mr. Chairman, members of the Select Committee, Co-Chairman Representative Western. My name is Daza Greenwood. I run the legal tech consultancy civics.com and also law.mit.edu, a research unit at MIT focused on computational law. And I want to thank you for allowing me to provide some testimony on the two proposed synthetic media bills. I should probably also mention I'm honored to be a member of the working group of the Select Committee that sort of initially helped develop the scope for this legislation. Although when we last met, it was quite broad, and the language of the bills is relatively new to me. I just read them when they were added to the committee's page, but I have reviewed them and I do have some comments on the language. I think regarding the civil penalties bill, there's beneficial aspects like empowering harmed individuals to seek relief and enabling the AG to investigate violations. However, the broad definition of synthetic media has just been discussed to some extent by the committee, and the lack of exceptions in particular, and the possibility of arbitrarily high damages raises some concerns to me when I read the language. So more precisely defining misled may also be prudent, as also has been discussed by the committee in the last few minutes. To me, it read as somewhat vague as a standard and open to subjective interpretation. On the positive side, the civil bill promotes accountability through enforcement powers and private remedies, and the visible notice for disclosure requirements, I think, balances some of the free expression interests pretty well. I appreciate that the bill aims to deter malicious synthetic media while maintaining freedom to create content for research, education, commentary, and other purposes. But I do think the language will need to be further defined in order to make sure those balances are successfully met. I think in contrast, the criminalization bill sends a very strong punitive message, but it raises free speech concerns even more in even a more dramatic way. Imposing jail time and criminal fines, I think, could stifle innovation and lawful uses of synthetic media. And the gap in enforcement mechanisms are also problematic. So in the criminal context, relying on the term misled for criminal liability, I think raises serious constitutional questions that could be addressed by setting heightened and clearly defined standards. Tying synthetic media laws directly to protection of a person's personal digital identity could strengthen protections by focusing them more precisely on misuse of a digital representation of identity without consent of the natural person whose personal digital identity is being abused. And I'm aware that, as it was said at the start of the hearing, that there's no action anticipated today for the bills, and there's going to be further work before action's taken. So in that spirit, I'll just say at a high level, my sense of what at the end point when action is timely, these revised bills might look like is they would define synthetic media more narrowly, and I would encourage looking at tying it to some extent into the existing Wyoming statutory definition of personal digital identity and misuse of that. They would continue to allow individuals that are harmed to seek limited civil remedies. They provide civil penalties for enforcement by the AG, continue to do that, and include some reasonable exceptions for public interest and educational uses. And I think generally avoiding or considerably narrowing criminalization, given this free speech concerns and other constitutional issues that it raises, would be very prudent. And then to take a much deeper look at the word misled, which is carrying a lot of weight in these bills, and consider refining it. In terms of misled, I think there's a few considerations around the word that came immediately to mind. The first word I would use to encapsulate some of my constitutional questions is vagueness. It's a somewhat vague term, and it is open to subjective interpretation. It doesn't define a clear threshold for liability, and this could make the laws prone to inconsistent or subjective enforcement. Some alternatives, I'm not proposing these as definite alternatives, but just the things that immediately popped into my mind that could be included in future conversations could be terms like deceived or reliance and harm as a kind of a mechanism. These are some ways to establish a higher, more quantifiable threshold for liability. Also, the other one I was thinking about just now is materially misled, or looking at material, adding materiality in possibly could help a little bit on putting a little bit more meat on the bones for the word misled. I think despite the vagueness concerns, misled is a common term in consumer protection law. Unfair and misleading, FTC and state consumer protection laws. So the courts have experience interpreting its meaning in those contexts, and there's some precedent. So I think it's a lot better suited to the civil bill. The other thing about misled is it could raise some due process issues regarding fair notice and the risk of arbitrary enforcement. So these are some other reasons constitutionally why it might be appropriate to further refine the term and set a higher standard. Let me just go a little bit deeper into this. So I think showing some sort of reliance and injury is another way to look at what the essence of the bill is intended to address. So instead of requiring simply that someone was misled, maybe requiring proof that they reasonably relied on and acted upon false information in a way that caused a tangible injury, that could set a higher threshold. I think using intentionally deceived rather than misled raises the bar. I'll leave that right there. I mentioned materiality already. Reckless disregard for falsity is a standard similar to defamation laws that I believe was already mentioned a little bit, and that shows that could require showing the creator acted with reckless disregard for the falsity of the content rather than just intending to mislead. Perhaps looking at some sort of proof of damages rather than minimum damages, could be helpful. And I think the other thing was looking at requiring public harm for criminal penalties is another way possibly to narrow its application. So for criminal liability, requiring prosecutors to show the deceptive synthetic media caused a public harm and not just a harm to an individual may be a way to kind of justify creating criminal penalties potentially, because jail time and criminal fines and a criminal record is a big deal. And so just in general, I think shifting from the somewhat vague term misled to more requirements of intentional material deception, reliance on actual injury or damages or public harm for criminal law, or some other heightened requirements could strengthen the synthetic media legislation against the free speech challenges, and also avoid the vagueness challenges while still protecting consumers and the public from malicious deep fakes. So in closing, I just really want to commend the select committee for proactively tackling this, I think, rather pressing policy issue raised by the emergence of generative AI, in particular deep fakes, which I believe is kind of the motivation for these bills, is looking at deep fakes and focusing on the legislature, focusing your legislature's attention on this matter now before deep fakes and synthetic media become ubiquitous and endemic, which I believe they're about to become, does show wise foresight. And I think it's very timely. And while refinements I do think may be needed in this initial language, the intent of the bills to protect against malicious use of misleading media is really positive. And with some careful deliberation, I think Wyoming has the opportunity to lead by pioneering thoughtful protections that balance safety and innovation and maintain our freedoms of expression and other constitutional guarantees. And I remain committed to constructively helping the select committee move forward as you continue to refine these bills. And I think while there's no easy answers, the dedication of the committee to show has shown in finding solutions is admirable, and I think Wyoming, yet again, as you've done in the past with blockchain and with digital identity, is lighting the way for the state, and I hope for the rest of the nation. So with that, I want to conclude my comments, and I'd be happy to answer any questions or to be helpful as requested. Thank you.
Thank you, Mr. Greenwood. Appreciate it, and appreciate your help in thinking through this legislation through the working group ahead of time. Any questions for Mr. Greenwood at this time? Any questions or discussion?
Mr. Chairman?
Yes, Mr. Pope, there you are. Go ahead.
If you were, thank you, Mr. Chairman. If you were getting ready to ask a question, I'm happy to.
No, go ahead, please.
Okay. Mr. Greenwood, thank you for your comments. I loved hearing them. I've got two questions for you, or two parts of kind of the same question, and they both center around the misled term. How would you define materiality? Because that, to me, for someone that has been a litigation consultant, materiality is different almost in every circumstance that I've dealt with. And then, what are your thoughts about a cause and effect type of way of limiting that that sentence? As I discussed earlier, causes to take an action that a reasonable person would not have taken, given the information at hand, or something to that effect. Thank you.
Thank you, Mr. Pope. Mr. Greenwood, go ahead.
Thank you, Mr. Pope, for your kind comments and also those extremely incisive questions. So part of the reason I like the term materiality is it sort of kicks the can down the road a little bit with a different word that can be interpreted in light of facts and circumstances, and that has a bunch of precedent that heightens the analysis and makes it more stringent and I think narrower than the word misled, but it is wonderfully broad nonetheless. And from a common law perspective, I think that's helpful. Some of the connotations that it has for me are some sort of misrepresentation that's substantive about relevant facts about a person that would sort of significantly influence opinions, beliefs, decisions made about the person by like an average viewer of the synthetic media. I think for material falsification, it sort of maybe it would be like depicts a person saying or doing something that's central or essential to their identity or reputation, or like involves their livelihood or personal relationships, like reputation, like your your comment about, or someone, I think it was your comment about being viewed next to Hitler, is like a quintessential example of something that would materially, impact a person's reputation, and in a sense, their identities partly based on associations and relationships. I think on terms of reasonable reliance, maybe if an average prudent person would reasonably rely upon as true the media as part of forming like an important opinion about the person's character or their words or actions, maybe something. Okay, I'm kind of out right now. Those are some of the things. I think if I had more time to consider the question and apply it, I could come up with some things. But I'll be honest, like it's another word that doesn't have like a super tight, IEEE specification on it, and so it's somewhat subject to good old common law application of facts and circumstances.
Great. Thank you, Mr. Greenwood. Appreciate it.
I forgot the second
right.
question, Mr. Pope, but maybe it's not needed. Or you had a second one, which is popped right out of my head.
Mr.
Yes.
Pope?
Thank you, Mr. Chairman. Mr. Greenwood, the second one was in order to further limit this, you have to show I would think you would have to show a cause and effect relationship, which, an example would be it causes you to take an action that a reasonable person would not have taken under this circumstance or something like that. And so I was wondering what your thoughts were about that issue.
Oh,
Go
yes.
ahead.
Thank you, Mr. Chairman. So I'm of two minds on this question. So I did just testify one legal mechanism to narrow the legislation, especially in the criminal context, is requiring some sort of showing of damages, and therefore we get immediately into causality and everything like that. And I guess the answer is you'd have to prove it, and you look at things like proximate cause and look at what the standard of evidence would be, and prove the case through whatever, and it would be very fact specific, I think. So you get, you could get, kind of expert testimony. You could sort of show a reduction in your salary. You could show that you were fired after something happened, and all the typical ways you show cause and effect, like in a litigation analysis. The reason I'm of two minds, however, is because in the civil context, I sort of wonder if the legislation were somewhat narrowed, especially if basically right now there's limitless damages, so like there's more of a cap on damages, or if it's narrowed a little more to something smaller, like per occurrence, maybe just the mere fact of having a deep fake perpetrated upon a person is all the showing they need. Like that itself is the violation, what we should reasonably expect in our society going forward. Maybe we shouldn't have to show much more after that. So anyway, those are my initial thoughts on cause and effect in this context.
Thank you. Appreciate that, Mr. Greenwood. Any further questions at this time before we go into a quick break? All right, seeing none, thank you. Please stick around. Look forward to hearing more from you. Mr. Greenwood will have some more discussions. And we will take a 10-minute break, and then we'll be back for further public comment on this topic at right around 10:15. So look forward to additional public comment on these two bills at 10:15 break.
Thank you.
All right, and we're back. We were, for the break, having public testimony on a couple of bill drafts, bill draft 24 LSO 0236 unlawful synthetic media criminal and 237 unlawful synthetic media civil. Those bill drafts are available online if you're listening at home, and I know that we have some more public testimony to listen to. I see Brendan. Brendan, welcome. Please introduce yourself once again to the committee, and the floor is yours.
Welcome. Can everybody hear me?
We can.
Great. Yeah, thank you. Thank you, Co-Chair Rothfuss and Western and Committee. My name, for the record, is Brendan Marr. I'm an MIT Media Laboratory alumnus. I am also a computer scientist, for the record here. And I'm on the working groups for digital identity and data privacy, along with Daza Greenwood. I've got a number of things which I would like to discuss and throw into the mix, which I think might be constructive for the committee to think about adding to the proposed legislation in a way in which will help define the definitions for synthetic media and narrow down the scope of the bill. First, I want to say this is really great. It's really, really important legislation. It's extraordinarily difficult to get right. The first thing I'd like to start up by saying is that I concur with Daza Greenwood that on the Digital Identity Act that we've already worked on, there certainly is a potential to, tie in and strengthen and bind together these two pieces of legislation. And going towards what others have said regarding organizations, in that the Digital Identity Act, there's of course the component of not only natural persons but organizational digital identity. So that's a venue or avenue that we can look towards. So the two other areas that I want to discuss briefly is synthetic media definitions, research and development, and distribution, and then the other salient aspect, which is how we have to be careful not to destroy the banking industry and the cybersecurity industry, because they actually play a crucial role in all this. So first on definitions, the definition for synthetic media needs to be firmed up. A couple things to think about more broadly is that we're thinking about this in terms of generative AI, but related to this idea of generative stuff is all sorts of generative stuff, including genetic algorithms and all sorts of things. And how information is generated is really important. So we want to be able to make sure that we do not, how do I say this? We want to make the distinction between research and development and production, right? Because really what we're talking about here, what the big concern is that when this information is released out into the wild, it's released out into the wild in a production form. So we want to make sure that research and development is not hindered, because it's actually the process of research and development which will actually help counter and protect us against this, AI fighting AI, right? So we don't want to hamstring ourselves. And we also don't want to make it, illegal for developers and computer scientists and others that are working with these materials, to get, caught up just by doing the work. So research and development distinction versus production is a very, very clear defining point, as well as this idea of consumptive purpose and what is the form of the generative AI. And this relates to to the form of this generative stuff. You know, are we talking about the production, the output form? Or are we saying that if you're creating generative stuff for the process of an algorithm, you know, let's be quite frank here, these algorithms are very complex. It's not just one thing, it's not just one algorithm, right? There are many different models, there are many different phases in the production of all of this stuff. And we don't want to say that if you're creating something that's generative, when you're creating that part of the algorithm, and in creating that part of that algorithm, if part of that process creates some generative stuff, which is binary, you know, it's not human readable, you know, it's not going to be something that you're going to see on you know, YouTube. It's still generative, right? But it's not for consumption, right? This is the salient point here. We don't necessarily want to, you know, limit that, or we do. We just want to be clear about that. I'll take a pause here, and I hope that provides you know, some food for thought. But I'll take some questions now at this time.
Thank you, Brendan. Any questions for Mr. Marr? Brendan, one thing that is same theme that we heard from Daza is the idea of ensuring that we have explicit language for research and education. I think that's something we should take note of to include as we look to the November meeting is to clarify that that protection. So that's a strong point. As far as to where we want to get, you know, give some thought to some language alternatives that appropriately narrow without over narrowing, which is obviously the challenge here. If we narrow, we create loopholes potentially. And if we fail to narrow, then we bring in things that we don't want to bring in. Else that you think of obviously over the next few weeks and into the next meeting, we look for some ways to strengthen that. Mr. Co-Chairman.
Thank you, Mr. Chairman. Brendan, I thought Daz, dovetailing on Senator Rothfuss's points, I think the educational component that Daz raised is absolutely valid and we need to be included there. But in your estimation, do you think it's, while good intention, that's another area that could be ripe for abuse in the sense that, well, what is educational? If you look at our 501c4 structure, that has to be used for educational purposes. I think there are folks who would certainly dispute that they are used for educational purposes broadly, at least with good faith. So do you think that's an option for it to be abused, or and then could we work around that while still honoring the intent?
Go ahead, Brendan.
Oh, sure. Yes, thank you. And to answer your question, I think that a large part of that workaround will come from how we define the definitions of production versus research and development, because there is a large chunk of the research and development stuff which is not in a form for consumptive purposes, right? These are they're vector databases, they're binary databases, they're not something that's viewable. This also raises the question regarding what is the form of the output, right? I think we're all thinking about, right at this point, we're thinking about it being video or audio, a video, right? And that's our biggest concern, especially with elections coming up and everything like that. We might want to be a little more careful in terms of how we define that output form. We're talking about just data that is generated like labels, like textual labels, right? And this gets to my point, which I didn't get to regarding the banking industry and the cybersecurity industry, right? There's a whole lot that goes on in these institutions and Fortune 500 companies, et cetera, regarding being able to synthetically generate data to test for fraudulent activity, right? That's part of the process of cybercrime investigations and algorithms, right? You need data to generate the algorithms, to test the algorithms before you test it on the data. We want to make sure that we're not, on the one hand, like, doing real great stuff for the consumers, but on the same hand, like, destroying the infrastructure that we have that's actually helping to protect us against all these things. I hope that's helpful, or maybe, I don't know. I hope it is.
Thank you, Brendan. Appreciate it. Any follow-up, Mr. Co-Chairman? Committee, any further questions? Yeah, on the educational side, echoing my co-chairman, I think there is a challenge where by simply saying, well, we were trying to educate people, even if it's false information, that is certainly something that provides an interesting protection that complicates it. So we'll have to craft that thoughtfully to ensure that educational use and research doesn't become a cover for deep fakes. Brendan, go ahead.
Yes, and this actually does, I believe, get into the questions or the statements that are raised regarding distribution, right? I think that is where that gets firmed up, and this is going to take some work, right? Because there's distribution is a thorny kind of thing, right? Because you can have information that is distributed. It could be an open source database. You're talking about that open source database as it being is it not only is it open source, but what is the format of it? So I think we have to look at these things in conjunction. The distribution part and whether it's production or not, and the intent around that, and bind these different things together. It's not going to be an easy task, so it's important.
Right. Thank you, Brendan. Appreciate it. Further questions, discussion? All right, seeing none. Who else do we have? Who do we have next? There we go. We've got TechNet. Welcome, Ms. Barco, I believe, to the Select Committee. Please introduce yourself, who you're with, and the floor is yours.
Thank you, Mr. Chairman and members of the committee. My name is Ruthie Barco. I'm the Executive Director for Colorado and the Central US, the Colorado and Central US region of TechNet. We represent, we promote the growth of the innovation economy at the federal and the 50 state level. Our diverse membership includes startups and some of the most iconic companies on the planet. We represent collectively over 4.5 million employees and countless customers in information technology, artificial intelligence, e-commerce, the sharing and gig economies, transportation, and cybersecurity, just to name a few of the areas on which we work on tech policy. Our comments represent the tremendous expertise that our members bring to the table on this issue and the consensus on our policy work as we work on this emerging area of innovation. Our comments are also for the purposes of both of these bills, and I will provide some additional comments on 237. So when we're legislating artificial intelligence, this must be approached very thoughtfully with a narrow and specific focus. Our role is to encourage responsible state legislation in this area, and particularly with the concern of the potential enactment of conflicting state laws, all of which would hinder the adoption and development of these emerging technologies. It was mentioned earlier by legislative staff whether or not there would be conflict with federal laws. That is an area that we have looked at, and we have not conducted a thorough review, but I'm happy to reach back out to staff on that issue if we discover anything, because this is something that we're looking at from a 50 state level and a federal level. We are concerned about the scope of this bill, and we would like to understand the intent of it. If it is particularly intended to encompass all malicious activity, then that may not just be generative AI content. That could also be content that has actually a human factor to it, where the scope of the audio was slowed down or a pause was added to make a public official look like they're inebriated or having a medical condition. So we would like to understand the intent of this bill a little bit more. If it is meant to only be synthetic media from a malicious intent, we feel like there could be just some better clarification around that. And we understand that this is a continuing discussion. So we are happy to suggest other language improvements as well as this continues. We want a little bit more clarity around the legal standard for misleading. That was discussed at length, and we echo Senator Nethercott's discussion there. And in paragraph A, we do think that specifying artificial intelligence in front of the word algorithm would help. We think that the definition of synthetic media could be narrowed to read the record actual events involving a natural person, that these need to actually involve a natural person and not just a portrayal of something that is non-human, because that further limits it to what we think would be generally accepted as deepfakes. We also think that machine learning would be helpful to add as a defined term. And we think that in paragraph B3 in both bills, there should be specificity about what is legally considered a deepfake. There is not necessarily one universally accepted technical definition of what a deepfake is, and synthetic media includes a lot of things that are not maliciously intended as deepfakes. So we want to ensure that this is not applied broadly to creative content. That was raised from a perspective of First Amendment issues. Creative content should be covered by First Amendment protections, and we do think that there should be an exemption, clarity around both that definition, but also an exemption for where the distributor has no role in the creation of that content. So I know that was discussed previously, as well as the comments of several of the members of this committee, but that's an area where we do think that an exemption has been used in other state legislation, and we do think that that exemption would be helpful. I'll give the example from a creative perspective and the distribution perspective. I mean, if you had a scenario where, let's say a deceased public figure or a deceased actor was put in a generative AI model to be giving an interview, and someone reposts this on their professional network and is talking about what a great interview this is and how fantastic it was, the comments that were made, but then they now discover that it's a deep fake. It was not necessarily a deep fake. Was this just created for parody? Was it just creative content? But now this person feels that they were both misled by it, that this person was still alive, and that it has damaged their professional credibility by them repurposing the content for their own platform. So would they be able to file suit under these laws? Would they actually have been misled? Is there actual cognizable harm to their professional credibility? These are all things that we think would be addressed by this being appropriately tailored to the intent of the bill. And we just want to understand more what that means. We do think that there should be exemptions for the use of AI and machine learning for cybersecurity purposes. There are also firms that are focused on developing cybersecurity tools to identify where deepfakes are being used to hack into someone's financial records, for instance. Those exemptions, while they would not meet, while that activity actually underlines the importance of this legislation, it actually needs to be protected as well so that those companies can't be found liable under it. And that's where we feel that there just needs to be a great deal of specificity. We do appreciate the chairman's comments on page 2, lines 10 through 12 about knowingly and intentionally distributing. But again, we want to understand what that legal standard would be. We don't think that that language in and of itself provides any level of actual certainty. Specifically to 237 on the civil side, we think that the penalties should be aligned between the two bills. That the civil penalties are a little bit more expansive. So we do think that that needs to be remedied. But additionally, the inclusion of a PRA, we find that to be a level of risk that is unacceptable. I believe Senator Nethercott talked about the class of plaintiffs that could file suit under this just by the nature of feeling misled. We think that the language about the vagueness of this language combined with a PRA is just a recipe for thousands of frivolous lawsuits, and especially if there is not clarity around whether or not the platform themselves could be sued. And we think that all of those must be remedied. We would suggest that paragraph C is actually removed in its entirety from 237 to avoid that. We do believe that enforcement by the Attorney General of the state of Wyoming would be the appropriate standard here. I welcome any questions from the committee. We would like to continue working on this, and thank you so much for the opportunity to provide our feedback.
Thank you so much. And Ms. Barco, you mentioned other legislation and language in other legislation that was different. What legislation would that be? Have you worked with other deepfake related legislation in other states?
So there's actually not a nexus. Thank you, Mr. Chairman, for the question. There's actually not a nexus necessarily with AI specific bills. There's actually other legislation that deals with content where a natural person is implicated. And specifically, I think there are actually bills dealing with quote unquote revenge porn, where they actually create an exemption for the platform where that's posted.
Gotcha. Understood. Okay. So it wasn't specific to deep fakes, but it was with revenge porn. All right. That makes sense. Thank you. Committee, any questions for Ms. Barco? Questions? Seeing none. Thank you very much. We appreciate the input. And if you have, I certainly took notes on some of the suggestions, but there are obviously a few key pieces here that we're going to be looking at and giving a lot of thought to. And one of those is that definition of synthetic media, getting that appropriately tightened down so that we're targeting what is intended to be targeted. Suggestions there would certainly be helpful. I think there's going to be a lot of work around that point. So thank you for that. All right. Anyone else on these bills? Okay, excellent. Anyone else in the public at this time? All right, seeing none. All right, quickly, go ahead, Mr. Stokes. So we've got one more bill ahead of lunch.
The parity aspect is something to consider, definitely, especially with what we showed you last night with the interactive AI personality. And if we incorporate, deep fake technology into that experience, and if somebody prompts the AI to create some content that might not be, go against the community guidelines, so to speak, and then somebody clips that and then distributes that, I think that adds a whole realm of complexity. But how would we go across address that issue?
Good. Thank you, Mr. Stokes. And I think again, on the civil side, the intent to mislead, knowingly and intentionally taking action. And then we've got a series of standards where you have to have an intent to mislead others about the acts of the natural person. Sets a standard, and we might need to work on that standard a little bit more. But with a jury using its judgment, hopefully some of the concepts, and I would expect some of the concepts that you're discussing, where you basically have a series of events that takes place where it doesn't meet this intent, I don't think would prove successful. Senator, what are your thoughts on it? Is that a fair assessment? Yeah. So again, we have to have some confidence, particularly on the civil side, that even though I know everyone's worried about lawsuits being filed and nobody likes lawsuits filed, we realistically created that entire branch of government to adjudicate and use their judgment. That's why they're there. And I don't know why we hate them so much. I kind of like them.
Let's take a moment.
Yeah.
Appreciate that.
Let's take a moment to appreciate that. Okay? It's a branch of government. It does its job. Thank you, Mr. Stokes.
There going to be further public comment
we will go to the next bill. And then I think after we'll see what the timeline looks like. I'm not sure whether we finish before lunch or whether we come back from lunch and finish that up. But that will be the end of the generative AI. We'll do general public comment at the end of the day as well as our last action prior to working with staff. Okay, sounds good. Thank you. Thank you, Mr. Stokes. All right. So with that, we're closing public comment on those two bills. We can come back to the committee for a bit of discussion. As we noted earlier, I don't think either bill is ready for action, but I do think that we need to know what we want for November and have a bit of discussion to figure out what that's going to look like. So, Mr. Co-Chairman, what are your thoughts?
Thank you, Mr. Chairman. I would absolutely agree. I think just not taking consideration, but working group's got its the working group has its work cut out for it. Certainly with honing down the synthetic media, including, the words generative and some of the other alternatives that have been suggested today, and as well as, misled. For November, it sounds like there's some hesitation on the criminal component of this, but I certainly think having a final product on the civil action, I think is really good. It's sticking with our original intent that we came up with back in the spring.
Thank you, Mr. Co-Chairman. Well, let's talk about that criminal aspect. I think that's something for us to talk about. I think everyone's probably comfortable with us having a civil bill. Discussion on whether to include a civil bill, a criminal bill, criminal in the same piece of legislation. We could put that in Title 40. As Mr. Hopkinson mentioned, there are criminal provisions in Title 40 in a similar manner to what we would have here that would then go alongside of what we have, or to keep them separate. General thoughts on whether to continue the path with criminal. Go ahead, Mr. Kaufman.
Mr. Chairman, I was just curious for those on the working group, if there was any input from any prosecutors as to what they're seeing, or how, if they're prosecuting cases involving the subject matter, what statutes they're currently using.
No is the short answer. And I think there is not a lot, there are not a lot of actions along these lines yet, right? This is certainly new. I don't know of any. I've actually seen some limited deep fakes that could potentially be eligible under this, but probably still aren't. So it's a little bit forward looking in that. And then I think in reality, when we look at libel and other statutes, the experience, and ask Senator Nethercott potentially to speak to this as well, is that because it's all based on financial damages, nobody prosecutes anything. Yeah, very challenging to pursue. So if we do have a criminal standard in this, financial damages do not seem like they would work to achieve the intent. Senator Nethercott.
Mr. Chairman, I think that's a valid question of Mr. Kaufman to ask what our prosecutors in the state feel about this bill. My experience on that topic is they don't provide much feedback on legislative work because of just how they're operating. And they don't to give generalized feedback. So it's a fairly ineffective ask of them. And I do think it's pretty novel that they're really just not seeing it enough. And if they did, I'm guessing that they wouldn't prioritize it in light of the personal crimes that they're experiencing.
Fair. Other thoughts on, really, we should probably make a decision, a general feeling for whether we want to bring it forward. And again, that doesn't mean we can't. If we bring it through to the November meeting, we can certainly make a further decision on it there, but I'd like to understand where the committee's at on the criminal side. Does everyone, go ahead, Mr. Co-Chairman.
Thank you, Mr. Chairman. I think certainly having both for consideration is good, but for the intent of what we're trying to do is have some regulation, some wording in statute to give protections and options for those who, who have been faked or who have been misled. I would think that's probably sufficient enough towards getting at or close to our intent that we originally had. And I think a criminal bill is not necessary. I mean, you and I have talked about before, we don't love putting more criminal penalties in statute, broadly speaking. So I think it's probably sufficient for now. That's kind of my hunch, but unless the committee feels strongly otherwise.
Thoughts? I mean, my inclination as the option, if we wanted to bring criminal, probably would be to just integrate a criminal provision into Title 40 as a exceptional circumstance. So basically start with the civil bill and add a and hopefully draft it in a way that we could make a decision on whether to keep that or eliminate it. That way we can have it for consideration still, but really have one bill for consideration. Is everyone comfortable with that? Senator Nethercott?
Mr. Chairman, so I am, to answer your question, Mr. Chairman, I am comfortable with that. One thing that I would bring up, and I mentioned this earlier, in 2021, House Bill 85, which is unlawful dissemination of an intimate image, where it's a crime to display. This is what it says: an act relating to crimes and offenses, creating an offense for the non-consensual dissemination of an intimate image, specifying elements and penalties for the offense. Much of this framework, I think, is applicable here, obviously with obvious changes, but it does provide a pretty helpful framework, I think, if we wanted to go down the criminal route with this type of topic. So I would encourage you to look at House Bill 85 from the 2021 session, of which I was the Senate sponsor.
All right.
With Representative
team.
Stiff as the primary sponsor.
Yeah. Thank you, Senator. We'll take a look at that. All right, well, on that question, then let's proceed with keeping that criminal penalty and adding it on as an addition within a single bill in Title 40. And let's take a look at House Bill 85 to see if that suggests other approaches. Other concepts, obviously, on let's kind of walk through real quickly and see if there's any general comments on what the committee wants to see a working group put forward on the definition synthetic media. I think we understand that we need to be a little more specific there and obviously change voice to audio, but contemplate generated by algorithms to perhaps generative artificial intelligence algorithms. We had a little discussion of actual events, record of actual events, and getting that specifically related to a natural person. Any further thoughts there on priorities? We can start with the same working group, but everyone's certainly invited. We'll send out if anyone's interested and wants to be a part of that, please let us know. Key thoughts on synthetic media? We've obviously got a lot of advice in that place. Mr. Pope.
Thank you, Mr. Chairman. Just a comment, if it's possible and available, I would love to be added to the working group.
Great. Let's make sure that happens, Clarissa. The B paragraph on 9 through makes publicly available. We need to make sure that knowingly and intentionally appropriately modifies both of those. Paragraph 1, without the consent of the natural person, we probably need to work out the concept of you have consent of the natural person, but the intent is for that natural person to mislead the public. So we'll have to find a little solution for that. Mr. Co-Chairman.
Thank you, Mr. Chairman. One thought or scenario that I think Ms. Barco did bring up was, I'm a celebrity, I've passed away, my estate is in control of my rights and all that kind of stuff, where this just simply says natural person, you could add or their estate or some kind of language to accommodate that type of scenario. Not a huge deal, but just, I think it's a valid concern.
Yeah, or they're authorized representative, something along those lines, and then figure out the alternative side if that individual gives consent, but that still is part of the act to mislead. I think we haven't had much discussion on paragraph 2. paragraph 3, intent to mislead others about the acts of the natural person. We should talk through characteristics or character of, in addition to acts of that natural person. And then page 3 and 4 on is whether or not we're looking at criminal or civil provisions. I think that's largely standard language, but one concept there is contemplating the maximum, and I do think we should have some discussion on this. The intent of money for somebody, the intent is to prevent this from happening, a deterrent. And the reality of what we're most concerned about is some large national organization with tremendous resources creating misleading information that ends up having a significant negative effect. This legislation certainly crafted in a way where you have on Romanet 4 exemplary damages in an amount less than $1,000 per plaintiff. That can be big, and that can be deterrent. Any thoughts on better approaches or concerns about using that heavy of a deterrent? Is there perhaps a way that we should be characterizing that to make it clear that it's for those mean anything? Is the court going to take that in a meaningful way? Yeah, Mr. Kaufman, what's exemplary going to mean to a court?
Yeah, exemplary damages are all often used kind of synonymously with punitive like damages. Yeah.
Mr. Co-Chairman?
Thank you, Mr. Chairman. I think leaving it in there is an adequate deterrent. The good appropriations chair certainly mentioned the concern about, well, does this create that class action type of scenario, a broader class? And that is certainly possible, but I think if the intention is deterrent, knowing that whether I am a large corporation or a sophisticated operation with lots of money or an individual out there trying to cause hate and discontent, knowing that there could be a lot of people that could come at me for each plaintiff. It's $1,000. If it's 100 people that see it, 1,000 people that see it, 1,000,000 people, as you say, I think it racks up pretty quickly. So I'm fine with leaving it in there if deterrent is our intention, which I think it is.
Yeah, I think deterrent is the whole intention of this, right? I'd rather never have it implemented because nobody would do it. Senator, what are your thoughts?
I think it's important as a deterrent, even by our efforts of creating this legislation for working this interim. Entities or individuals who are interested in doing this, that there will be legal remedies associated with it. So I say for now, we keep it all in.
Okay. Anyone disagree with that? Without objection, let's leave that in. All right, oh, go ahead. I'm sorry, Mr. Pope, I see you up there. Nope, you muted yourself, Mr. Pope.
My apologies, Mr. Chairman. The Romanet 3 and Romanet 4 are equalizer sections where it equalizes the small guy with the big guy, basically. And yes, I agree that it needs to stay in there. I think $1,000 per plaintiff is it is a good place to start right now. But keep in mind the courts are not required to, as far as I can see, apply those damages, because above it says a court may award any of the following remedies. So Romanets 3 and 4 are not required for the courts to apply those. It's if they do, it's a minimum or not less than $1,000. And it certainly seems to me also the court could add to that as well, based on the language.
Agreed, Mr. Pope. Thank you. All right. Any further thoughts, any other points that the committee wants to make sure is considered as we're drafting this in November? And we'll try and get that work done early, start circulating it, and make sure that we have time to provide drafting feedback on how to integrate this. Does that sound good? And again, feel free to let co-chairman or I know if you're interested in being a part of that working group. All right. With that, Mr. Co-chairman, any final thoughts on that, or shall we move on to the next bill?
I think we've got a nice little bill, Mr. Co-chairman.
Very clear right now, right? All right. With that, let's move to 24 LSO 239. Artificial Intelligence Foundation Model Registration. And Mr. Hopkinson, if you can walk us through that.
Office, walking through 24 LSO 239 Working Draft 3, Artificial Intelligence Foundation Model Registration. One thing to note about this draft and kind of highlighted a bit in the staff comment, there are some considerations that I think are kind of left open the committee could make, including, what exact information should be required to register, whether that registration should expire after an amount of time, and whether or not it should be removed from the registry, as well as things of requiring a rulemaking deadline for the Secretary of State's office, providing a consequence for failing to register, because the bill doesn't currently do that. And a number of the comments that I had on the previous two bills can apply here. There's potential to be over or under inclusive on what exactly is a foundation model, and who would be required to register. But as drafted, it creates a new chapter, Artificial Intelligence, in Title 40, and provides for foundation models as the first article. And the definition there, foundation model, means a large-scale machine learning model trained on a broad data set that can be adapted for multiple tasks. And then machine learning is defined as a computer system capable of developing algorithms without direct human intervention. You'll note that there is no definition of artificial intelligence, despite that being the chapter that's created. And part of that is just the challenge, really, of providing a clear definition of artificial intelligence that meets all the needs. And so that may still be something that the committee wants to include there. And similar to the synthetic media definition, these are really kind of levers on what exactly we want in here, because some of these terms can be broadly interpreted potentially. And so I've tried to make it specific and narrow, but it may not hit the mark. So that's certainly something for the committee to consider. So with those definitions in mind, the next article created is Foundation Model Registration. And it requires that any person who makes publicly available within the state of Wyoming a foundation model or the use of a foundation model shall pay a fee of $100, the amount, of course, up to the committee, to register with the Wyoming Secretary of State, and shall include the name and business address of the registrant, and if a corporation, the state of incorporation. And then subsection B simply requires the Secretary of State to promulgate reasonable rules and regulations to carry out the purposes of this article. So it's a little thin, but that's what we have, and I'd certainly stand for any questions.
Thank you, Mr. Hopkinson. Any questions for Mr. Hopkinson at this time? Go ahead, Mr. Kaufman.
Thank you, Mr. Chairman. I'm just curious, Mr. Hopkinson, in your research, have any other states enacted anything close to this at all that you're aware of?
Mr. Hopkinson, go ahead.
Thank you, Mr. Chairman. Not that I'm aware of.
Any follow-up?
I'll wait for
Okay.
further comments, Mr. Chairman.
Thank you. So the discussion here, the concept here is just at the basic level, and it's a policy decision. Do we want to know if artificial intelligences are being used in the state of Wyoming, large ones. These are foundation model level, and the concept there is that these are the large scale machine learning models are operating. Is that something that the state of Wyoming should be aware of? Yes or no? And that's the discussion point that we're kind of looking at. Mr. Co-Chairman.
Thank you, Mr. Co-Chairman. And building on your comments a little bit, certainly part of this was just the discussion that we as co-chairs had, and I think with other folks at our last meeting. And if we recall, Mr. Sam Altman, who's the CEO of OpenAI, testified. I think it was the day of our last committee meeting in May. And one of the things that he advocated for when he testified before the Senate Commerce Committee was having some type of licensure mechanism. And so I think we want to be careful, of course, by not stifling innovation or going too far, but also having some type of stopgap measure to ensure that there is a regulatory presence in this sphere. This bill is obviously very light, I think intentionally so, and I appreciate David for keeping it that way. And it kind of gives us, no pun intended, a foundation to build on of what we want this to look like in final form. So I think it's absolutely a great use of our committee's time for deliberation.
Thank you, Mr. Co-Chairman. Yeah, Mr. Coppin, go ahead.
Mr. Chairman, forgive me. I'm going to come out swinging.
Sure.
I think, I mean, just my own candid opinion. I think this is the wrong message for Wyoming to be sending. I think it's a terrible idea, frankly. And there's a smorgasbord of reasons, right? The most important of which is most of this software, and we heard testimony on this from a whole host of experts back in May, right? When they presented us and walked us through the machine learning protocols they were developing and how they used them. But a whole lot of those are based upon open source software and technology. So are we going to be a state that's now requiring people who are utilizing open source software to somehow register? I mean, I can think of 20 software clients off the top of my head that would just have outrage over that because of A, the fact that no other state is doing anything like that, as far as I'm aware. B, the competitive risk. I mean, C, it's forcing you to sort of identify your technology in a box that they might not want to be identified in. And ultimately, what is the purpose, right? Is the purpose just so if this technology is misused by someone that you can easily identify who it is, right? Because problem, but maybe not. So I'll stop there, Mr. Chairman, but for a whole host of reasons, and I suspect we're going to hear from the technology community the same thing, that there's just not any resounding good reasons to do something like this, particularly based on what we know now and with how quickly this technology is developing right before us.
Thank you, Mr. Coppin. And I think that is the concept, is the last thing you said, which is just to know who to contact. It's certainly not the $100 application fee that's in there, which is of no consequence. It is the, if AI is being used and you know, there could be the standard of if it's being sold into the state, if there's service offered for hire, something along those lines, there could be different standards to avoid the open source. The concept, it really comes down to, from a governance standpoint, and from a public, like a consumer public protection standpoint, what would you do? How would you engage? How would you know what to do if there are concerns related to an AI foundation, one of these large models in the future? And again, I don't disagree with any of your points. It's just a good point of discussion early on. What is the role of government with regard to artificial intelligence, and is there a role at this point in time for us to take? Thanks for those points, Mr. Co-Chairman.
Thank you, Mr. Co-Chairman. I certainly think that those are valid concerns. A lot of this does come down to how you interpret stuff. Someone could certainly see this as saying, well, they're trying to send the message that Wyoming isn't open for business, or you know, that we're not welcome there. I think quite the opposite. And I think our track record clearly shows that. I do think certainly in the tech realm and just across industry in general, good actors want regulation. They want to make sure it's sensible. They want to make sure it's fair and balanced. But vast majority of the time, they want some type of regulatory structure. Is this bill specifically it? I don't know, but I think we all know that AI, that these large language models are having a huge impact now, and that's only going to be magnified in the coming years. And so I would say that would be my thought. Would be, I would imagine a lot of actors, whether again there's technical nuances, the open source question, I think that's absolutely fair, but they generally want some type of regulation in place. Obviously, that's fair and balanced, but having something is generally good. And I'll be very curious to see some of the folks who hopefully testify and submit comments.
Great. Thank you, Mr. Chairman. Thoughts? Go ahead, Representative Andrew.
Thank you, Mr. Chairman. I would argue that not necessarily good, but large actors are the ones, sorry, are the ones that want regulation. Oh, sorry, it's in my throat. And because of that, I think that is why we see those types of companies as the ones who are pushing for this type of regulation. And this isn't necessarily a massive roadblock to innovation, but it's certainly a speed bump. And, the more that can be put in the way of small companies trying to compete with large companies, the harder it's going to be for them. So definitely not an advocate of pushing this bill further forward.
Thank you, Representative. The foundational model, just to be clear, that level at least contemplates entities that are already talking billions of dollars, and most of the foundation model entities are in that realm of capitalization, and they'd have to pay around $100 and register. All of the startups that I think you're concerned about, the folks that are innovating, they've got a long ways to go before they've trained a foundational model in AI. And I don't think this wouldn't affect them. This would actually, in my view, be intended to be structured only for those larger players that would be effectively operators with significant presences. And I don't know if that assuages your concerns, but just to clarify, I think it's important to note that if you're a small startup building your own little model, you're not rating a foundation model. Any additional, you can go to public comment, and I think we'll start with Mr. Greenwood if he's hopefully still on. I know that he's been giving some of this a lot of thought as part of the discussion. Yep. Oh, my apologies. Okay. Mr. Greenwood, we're going to start with Secretary of State's office. We usually start with our agencies first, so my apologies. Let's go to the Secretary of State's office first, and then we'll go to Mr. Greenwood next.
Thank you.
Can you hear me? There we go. Yes, we can. Thank you. Welcome.
Okay. Thank you, Chairman Rothfuss. As you know, I'm Chuck Gray, the Wyoming Secretary of State, and to my right is Colin Crossman, our Business Director, and Joe Rubino to my left, our General Counsel and our Policy Director. Our comments today are focused on our possible implementation of the bill and whether we can implement it. And after review of this bill, I wanted to briefly note that it can be implemented by our office. If the bill passes as written, these AI registrations would be implemented into our existing business registration system, WyoSuite, using our existing miscellaneous filings module. As such, the bill would have no technical fiscal impact in its current form. Thank you.
Thank you, Mr. Secretary. Any questions for Secretary of State? All right. Seeing none, thank you very much. We appreciate your time and appreciate the very quick and brief overview of that.
Thank you, Mr. Chairman. Appreciate it.
Thanks. All right, now over to Mr. Greenwood.
Thank you, Mr. Chairman and co-chairman and members of the committee. I appreciate the opportunity to provide some input on this bill as well. I do think it's very timely, and I was one of the people during the last session that suggested that some kind of lightweight licensure and disclosure model is definitely worth exploring at the state level. I think now that we've sort of seen legislative language, I do have some suggestions on the wording. The first thing that popped right out at me was the definition of machine learning and foundation model. And these are terms that should be more tightly defined, I think, for legislation of this type. In general, foundation models are ones that contain, a lot of parameters, like 10 billion parameters or more, or sometimes many more. So one way to look at putting more meat in the bones of a definition is how many parameters are involved. They are trained on broad data sets of diverse forms of data that represent general knowledge about the world. They demonstrate capabilities in understanding and generating or reasoning about natural language or sensory inputs. They are created. The other thing is they're thought to serve as like a baseline model for further training and specialization, like for fine tuning, for example. That's the idea of foundation that you build more layers upon, and they're accessible to third parties for use or adaptation. There's another dimension here that's been emerging over the last few months, which is further distinguishing from foundation models to this even in some ways narrower term called frontier models. And I think we talked about that briefly in the last working group call. And so at a high level, these foundation models achieve or surpass human level performance on narrowly defined tasks that require reasoning, prediction, conversation, content generation. They sort of push the state of the art in measurable terms against consensus benchmarks for assessing capability. So they're at the top of all those evals that you see when big models are released. They require substantial computational resources and data infrastructure, or modeling advances to train and deploy them and to do the inferences. They're not necessarily widely available to third parties beyond their creators due to sort of competitive and ethical and legal and security considerations. But I do think they're of the smaller type of models that were of the type that might be good candidates for licensure when they are released for general use by populations in Wyoming. The other thing beyond the definition of the models is the registration criteria. And I think the bill in the future version should provide clear criteria for when a model is deemed publicly available and therefore, achieve the trigger event for registration. I think the bill should specify what would be disclosed as part of registration process. And there is some information on that there, but some more things to think about would be a description of the model architecture, maybe an overview of the training method, some summary of the statistics on the composition of the training data set would be helpful. Its intended capabilities, going back to the benchmarks, like the results of standardized benchmark and evaluations that were applied to the model. Maybe a little bit more context on the deployment overview. So is this sort of available to everybody for free by going to a website, or is it available how is it being deployed in the state? How is it coming into contact with the people of Wyoming? Maybe something about the policies for monitoring and mitigating ongoing harms, security assessments and protections, like beyond the performance evaluations and benchmarks. This is sometimes called the model card, and GPT-4 and Anthropic's Claude 2. It's already sort of a practice to release the red teaming and the model card for security, but that would be a very helpful thing, I think, to know. And if there's maybe human oversight and safeguards to prevent misuse would be another thing that would be interesting to know. I think some rationale for the fee structure would be beneficial. Perhaps, at least I'm more familiar with Massachusetts and California, but the $100 registration fee, I just wonder what that relates to. In terms of oversight and enforcement, I think it's really excellent that the Secretary of State's office testified that they can do this. That changes the entire complexion of this conversation in my mind. It just makes it very real. It also raises a question of the scope of the bill. So for licensure and kind of like disclosure, this is right on track. The context within which licensure has come up in the hearing that was mentioned earlier, the federal Senate hearing, where Sam Altman of OpenAI and other witnesses testified that they'd be very open to a licensure requirement, also included oversight and auditing and enforcement for noncompliance. And I'm not sure if the committee is aware of this, but just within the last few days, Senators Blumenthal and Hawley have put forward a licensure proposal following up from those from that hearing, and I think it's very important to keep tracking what's happening federally when creating state legislation, because of the sword of Damocles of preemption, and also just making sure that things are fitting together well. Having said that, I should have opened with this statement. I actually think it's very helpful to look at a lightweight licensure and disclosure of some type at the state level, to the extent that these models are being deployed within the state. And I think it could be a long time before anything happens federally. It may be the only licensure people in the United States and the world have to go on would be in Wyoming if you did this sooner for a long, long time. And also it's helpful to have models out there others can follow. One other thing is the scope of the bill in terms of not just the definition of foundation models, but also its application to like open source and to genuine research, like nonprofit academic kind of research. So I think in addition to the above kind of clarifications or amendments I suggested, the inclusion of some carve-outs might be appropriate. So these exceptions could serve to encourage more innovation and support research efforts and ensure the regulation doesn't impose an undue burden on smaller entities or those that are contributing to the open source community. So open source models, I think, are really crucial for this technology. And the models frequently form the foundation of a lot of academic research, and they feed into startups and into bigger companies as well, and other community types of usages for this technology. So it could be beneficial to exclude open source models from the registration requirement, or if not excluding them entirely, maybe provide like a reduced fee structure or some reduced burden in some ways to recognize that you're not trying to freeze out open source models or to treat them in the same way. To qualify for a carve out an open source model could meet criteria like the other thing about open source models is they're open source, so you can actually, I think, reasonably ask for more information. So as part of treating them differently, the model could be required to include more about its architecture, and then this is critical, its weights. So the weights are the whole thing with these models in order to be able to reproduce them and to completely understand them. So having those publicly available in an official place as part of a registration could be really useful. Maybe documenting in more detail the internal training and confirming that just maybe defining what open source means. This has become somewhat controversial now in the generative AI kind of circles. There's questions about whether like Llama 2, for example, is or isn't open source. It's open in some ways, but there are some restrictions on it. There's questions whether to be open source, it has to permit nonprofit and commercial use or not. And there's a lot of gradations in how these things are being licensed now. So think that's a policy question, what would or wouldn't be included in the carve out. I think research is the other thing. So often these research models are developed in academic or nonprofit settings, and that's really essential to advancing our understanding of machine learning and AI capabilities. And the models typically are not deployed at scale, and their development's often resource constrained. And to support sort of research efforts, I'd suggest a carve out for models developed and used exclusively for research purposes. And to qualify for such a carve out, conditions like this could be met. The models developed and used by a recognized academic or nonprofit research institution. The model's not used in commercial product or service. The findings from the use of the model are made publicly available in a way that respects privacy and confidentiality from the data. And the idea is basically if there were such carve-outs, to balance the need for regulation and oversight of large-scale machine learning models with the imperative to continue fostering innovation in this field. So in conclusion, I believe that these amendments or the further clarification of this type could help strengthen the bill, strengthen its enforceability and its effectiveness. And I just really want to encourage the select committee to continue looking at crafting a bill of this type in a way that could address the concerns that have been raised by other members of the select committee, but still provide at least some way to provide some transparency and just disclosure of these core models that are deeply, profoundly impacting people's lives and businesses and the body politic within the state of Wyoming. And I want to thank you for considering the suggestions and the opportunity to provide input on this legislation, and I'd be happy to remain available for further discussion or clarification or to answer questions. Thank you.
Thank you, Mr. Greenwood. Questions for Mr. Greenwood? I have one to start. Go ahead, Mr. Co-Chairman. I see your hand up.
Thank you, Mr. Chairman. Guys, I really appreciate all the work you've done on this within the working groups and just testimony just like this. I think it's really helpful. Kind of sounds like we've got a rough template that needs a lot of work, but there's a lot of good potential there. My question, weights and open source versus not, but I'm curious, what would that specifically look like in terms of the words on the page? I mean, is it sufficient to say if your weights are calibrated in this way, you're exempt from registering? Like, is that kind of language adequate, or what would that look like in terms of actual verbiage?
Mr. Greenwood?
Yes, thank you, Mr. Co-Chair, for the question. I think that sort of generally, it would say something like it would lay out the language as it exists in the bill with Section A with definitions and then 432.102 on the registration requirements. And so in the definitions, you'd include a definition for open source or research models. And then down in 432.102, it's based on the current structure of the bill. In registration, I think you'd add a section like after A and before B, the current B, where the Secretary of State promulgates reasonable forms, that would indicate a kind of a carve out or a different treatment for the open source and research models, and that they would either be exempted in the case of perhaps small models, or in the case of a big model that is a foundation model and also happens to be open source. And I'm thinking something perhaps like Llama 2, which I use almost every day, by the way, alongside Claude 2 and GPT-4. That it may include the additional requirements to disclose things like their weights and additional information. If that's what you're asking, it may also perhaps include that there's a lesser fee, an exception to subsection A that currently defines $100 fee. It may say for these open source or research models that are also foundation models, a lesser fee is required. So that's how I could conceive this structurally coming together.
Thank you. Follow up, Mr. Chairman. So, Mr. Greenwood, I have a kind of question at the heart of the legislation, which is the public interest of the registration. And really, why would a public registration of these larger AI models be in the public interest such that we should be implementing this at this time? What are your thoughts on that public interest? And part of that is coming down to if we do observe a strong public interest, then what legislation is going to most effectively achieve that public interest by balancing the other interests. So what do you see as the primary public interest of an AI registration?
Thank you, Mr. Chairman. I believe that having a very lightweight licensure and disclosure requirement of this type is helpful, specifically because, number one, this new breed of AI, this generative AI foundation model capability set level is I don't want to be too hyperbolic, but I want to say it's changing everything. We just haven't yet seen how profound these changes are in practice, in people's lives, in business, in government, in civil society, in the economy. I think the impacts are profound. And the implications of the impacts are not yet clear. The first step that I think is proportional to start to address these as part of a state government is just being able to individually identify and enumerate and like name these things is the very first step to keep an eye on them, to make sure that people kind of know who to call if they have questions or issues. The same way you license foreign corporations, like any corporation doing business that's incorporated elsewhere and doing business in the state of Wyoming, there's a deep public policy imperative to make sure that they're identified, enumerated, tracked, and capable of being addressed by people in Wyoming who are interacting with these corporations. The capabilities of these models in some ways are greater than the capability of almost any corporation that's a foreign corporation doing business in Wyoming, because they go right into people's lives, into all their interactions that they use them for at any rate, and they can have profound implications for what they're communicating and what they're able to do. And so I think the very first step is just being able to disclose them and to provide sufficient information to be able to kind of enumerate and track them. And then over time in 2024, 5, 6, and down the line, as it becomes clear where there may be gaps in state law applicability to these models and where market failures or other need for action may become more definite, then there's a basis upon which to begin to regulate by having these models licensed to start with. So to me, it seems like it seems like there is an important public policy in having disclosure and licensure. It seems like if it's done well, as it's beginning to be done well in this draft, has very little negative consequence, especially for the very few models that meet a more stringent definition, and that it's a policy foundation for beginning to be able to address these critical new entities in a state law context.
Thank you, Des. One other kind of related question along those lines. You mentioned, with this motivation, a few minutes ago, you suggested that there'd be some delineation with open source and other projects. If the key concept is that larger operating foundation models are registered so you know who to call, so to speak, and what's going on, I guess I don't see why there would be any different treatment regardless of what business model they were using, you'd still want that same type of information, assuming that they were large enough. So it would be the scale that would matter more than the business purpose that would matter if the intent is to just know what's going on. So I guess I don't see that delineation.
Yeah, thank you, Mr. Chairman. I agree that there's in some ways no difference in terms of a foundation model that's open source or private with respect to the need to the desirability of having licensure and some disclosure, then some kind of contact information for the core group behind the offering. Partly where I think it's different for foundation models that are also open source is that there's a real opportunity and I think benefit to having more disclosure. In particular, I want to stress the weights of the model. Like they're already available if you dig through, you know, the GitHub repo and so forth. Having them directly associated with the model are helpful, and also more information that would otherwise perhaps be proprietary or confidential can also be disclosed. And I think there's a possibility that lowering the fee is appropriate for nonprofit, non-commercial projects. You know, $100 is not that big of a fee in some ways, but it's not tiny. And I'm familiar with some open source projects where you know, $100 fee is the matter of some debate. And I also think it signals having a lower fee that that open source projects are different than commercial projects.
Thank you. I guess the concern I would have is that a circumstance where, as we discussed earlier, $100 should not be a big deal to anyone that's paying $100, so to speak. And if you think that there would be open source projects that would be worried about a $100 registration fee, where you ask why the $100 registration fee, it's just the standard Secretary of State's office is doing not a real tricky fee structure. But you think there could be open source projects that would achieve a foundation model and would care about a $100 fee?
I apologize, Mr. Chairman, but your audio cut out for part of the question, but I believe I got the gist of it, which is just kind of some incredulity about my assertion that a lower fee might be appropriate for open source models. And sure. Okay, good. Thank you for that, Clark, confirmation. Yeah, I take your point. The essence of my testimony here is that open source is different than commercial offerings in general. And I think when it comes to, I think some of my instinct here is that like a very pure open source project is fundamentally all volunteer, okay? And signaling that through things like fee structure reductions, I don't think is inappropriate. I think where it gets weird is when you've got an open source model that's being delivered by a very wealthy corporation that's supporting it financially and putting, you know, full-time paid staff on it. In situations like that, I think, you know, a regular fee structure is entirely appropriate. I don't really want I think the main points of my testimony relate to the other matters that I mentioned in terms of the definitions and the disclosures. The point about the fee structure, I think, is extremely minor, and I'd be perfectly happy if the fee structure was the same. I love open source, and I would love to see a way to have my love of open source, you know, considered by the select committee in a way that, you know, that doesn't that provides them some proportional recognition of the open source nature and frequently of the volunteer nature of the project.
Great, understood. Thank you. Any further questions for Daz at this time? All right, seeing none, thank you. Please stick around. We might have some more follow-up conversation with you on this.
Thank you.
Committee, and the floor is yours. Jared, can you hear us?
Oh, I can now. Yeah, your audio is going in and out, so we can hear you sometimes, and I
Oh.
didn't hear you.
Yeah, I'll
I didn't hear
switch
you call on me,
microphones. Maybe that
so.
one's better. Yep. Jared, the floor is yours. Please introduce yourself and take it.
Great. Thank you, Mr. Chairman, committee. My name is Jared Stack. I am the CEO of a machine learning AI company based in Casper called FlowState. I'm also very involved with the startup and tech community here in Wyoming, and I guess those are the two reasons I'm here to talk with you about this proposed bill. You should have in your inboxes some written comments that I gave you yesterday. I won't belabor those as well. I'll kind of briefly.
We have those. Thank you for those. Yep.
Yeah, great. So I won't go into those. I think those are probably more eloquent than what I'll say today, but I do have a couple big concerns over this. And most of my concerns are really kind of like fundamental of why we'd want to go down this route. And then I had a kind of some detailed things that I'll go into as well. But I really, and Mr. Kaufman alluded to this earlier, I really don't like the message this sends. You know, we are basically taking one piece of technology, because we don't make any other technology companies register their models or their code or their whatever, right? We're singling them out and making them register something that is pretty ill-defined with the Secretary of State's office. And I don't know how often you have to register them, and how often you have to do that, and all that kind of stuff. That the logistics of those are a question as well. But it sends a really bad message that we're not trying to go build these kind of things here in Wyoming, and I think we should be. And it sends an even more message that we want to be maybe the first to regulate AI companies. You know, I think Mr. Greenwood's testimony didn't even allude to it. It straight up said it, that this is the first step towards much more regulation, right? And the first step is towards doing that. So I don't really understand why we'd want to do that. And if we take, you know, what I think you're trying to do here is let's go get the couple dozen really, really big, you know, people that have put hundreds of $1 millions into these things. So make them register it. It's no secret. Like if you just want to know who the contact information is for OpenAI, it's no secret who that is, right? So it's not like that's something special that you need to go find out. If you're only looking at the two dozen of these or whatever they're out there right now, have some intern at UW go research them and find out who the contact information is, right? Otherwise, you're going after the little guys, right? Yeah, well, you're trying to get all of us to go register that. So I think, you know, that's my concern. And my other concern is that it's just very risky of how we're going to go build the regulations around this, what we're going to make people disclose to very little reward. I don't know exactly what we're trying to get out of this, but I think there's a lot of risk of what could potentially happen with some unintended consequences and things like that around this. So I think those are my high level concerns. If you get into the language of the bill, and I appreciate this is very preliminary, but it's really vague as to what is a foundation model. And I think even more importantly, what is making it publicly available to the people of Wyoming. Right. So, you know, there are literally thousands of applications out there right now that take a foundation model, build upon that foundation model, and make it available to people. Right. And by the letter, and I think any concept of this, all of those people would have to register. Right. You know, you can kind of flip this on its head. If you look at what they're proposing to do in Europe, they have a team that is going out and they explicitly name, here are the 14 foundation models. And those are the ones that we're going to have to go do more stuff with, right? As opposed to having them all voluntarily registered. So I think we in our heads, we kind of think of there's these big, huge GPTs and Llama and some of those kind of clouds, some of those things that like, this is what we're thinking of a foundation model, but it is actually becoming, I don't want to say trivial, but very easy for me or someone like that to take a foundation model, build upon it and make it publicly available. So while there are only a handful of these kind of really big ones, if you look forward, you know, this is not a very future-proof bill. If you look forward, there's going to be more and more. It's going to become easier and easier to go build what these large things are. And I just don't know where it falls in. I'm also concerned about setting up some state-by-state licensure standard. You know, I mean, if any of you have like an e-commerce business or like that and try to sell across state lines, like trying to figure out your sales tax is an absolute nightmare. And this is what this is setting up, right? Is every state's going to have some different language or different things that we're going to have to go figure out and do this. I also, and I appreciate the Secretary of State's office coming in saying that they could do this easily. I would actually question that. I mean, I think if all you're going to do is have us register these like I register my LLCs, I think that probably would be pretty easy. But if you're actually going to go enforce it, you're going to go figure out, are you a foundational model? Are you not? Are you going to have them register good God, their weights and stuff like that, which probably we need to go into a comment about what there is, but nobody's going to want to do that. There's a whole bunch of infrastructure there that there needs a lot of expertise to be able to understand what that is. And I'm not sure we have that. So I'll kind of end it there and take some questions. I think there's much more in my written comments there, but I really think we're going down a path here that is risky, that I'm not quite sure what we're going to get out of.
Thank you,
Thank
Mr.
you.
Stack. Any questions for Mr. Stack? Appreciate your time. Go ahead, Mr. Co-Chairman.
Thank you, Mr. Co-Chairman. Mr. Stack, I do appreciate your concerns, and I did read through your written testimony and I listened to your verbal. As I said to Mr. Kaufman, I can certainly see how that the initial message this could be sending is, well, we're not open for business. And I think it's safe to say, to assume that you understand that the broad reaching consequences of this type of technology, if this isn't it, what is? Because sooner or later, and this has just been modeled throughout history, through industry, in the absence of some type of regulation, the temptation to behave in ways that may or may not be publicly beneficial is strong, and it only gets stronger over time. And so if this isn't it, what is the answer?
Mr. Chairman. Yeah. So
Go ahead, Mr. Stack.
Thank you. So what I think maybe to restate my concern, painting us all with a broad brush of like you all have to register all of your models is not solving any of the problems, right? If I'm going to be a bad actor and I'm going to have this, I'm just going to skip it and not register it anyway, right? I think the previous two bills that you guys discussed are more specific around here's the bad things that this technology can do. Let's put sidebars around the bad things that can happen. Right. And make that what we focus on, as opposed to let's just make you all register everything. So we have a list of it, as opposed to going to actually build legislation around what your concerns are.
Thank you, Mr. Stack. Mr. Co-Chairman, thoughts? Go ahead.
Thank you, Mr. Chairman. And I do appreciate that, the nuance of saying, well, let's focus on these guys and not just paint with the broad brush, as you say. And I think that's a really good point. We should continue to take that in consideration as we work this bill. Trying to formulate my thoughts here. I think part of it also is a momentum thing. Look at what the social media companies have done in terms of dialogue in America. Not been good. And if we look at the legislation, the regulatory, why did they fail? There's a lot of reasons, but one of the big high level reasons was they were so big and they could just hire an army of lobbyists, and because all this momentum already built. Certainly some of these AI companies have momentum, but it's nowhere near what the level was with Facebook in 2016, 2017, 2018, when that debate was raging in Washington right now. Whereas we are at a point in time where they have not garnered that level of momentum and that level of influence over society the way they do now. And this piece of legislation might not be it. In fact, it certainly might not be, but we are at a point in time where I think it is wise to do something. Where I think doing nothing is just not acceptable.
Mr. Stack, response?
Yeah, thank you, Mr. Chairman. I agree with you 100%, Representative Lester. I mean, I think and you'll see that from the whole AI industry. We agree that we need to do something, right? There needs to be sideboards put up around what we're doing. I just argue if this is it. I think the previous two bills you guys worked on are exactly what we should be doing. We should be finding the things that are potentially wrong with this. And if you can go, not that I would ever be the person to advocate, let's go look at what Europe's doing and copy that. But if you go look at what they're doing towards this, they're really looking at these not only foundation models, but AI models, and let's take the risky ones. Let's figure out what the high risks are, and let's start talking about those specifically, as opposed to just treating everyone the same. Thank you, Mr. Chairman.
Well, on that, Mr. Stack, I think the intent, we can't be calling out specific models in statute. So the intent of foundation model definition would be to basically characterize it such that it would be those same entities. I think that was the discussion leading into it. That's not to say that the definition currently does that, but use cases are not the same as foundation models. As you pointed out, you're using a foundation and then you're adding on to it and building a product, commercial use on top of the foundation. So your commercial use is not the intent here. The foundation as intended. And again, it doesn't necessarily get there as drafted, but that's at least the intent of the draft that we're discussing, is to get at the same ones that you're discussing. But I certainly take your point. No question about it. Further questions for Mr. Stack? All right, seeing none. Thank you, Mr. Stack. We appreciate your time.
Thank you, committee.
Do we have any more at this point? Okay, Mr. Marr. It's almost lunchtime. Mr. Marr, let's come on. We're going to have a hard stop if we can at noon, and then maybe come back and discuss this after lunch. So you've got about 6 minutes ahead of our noon break. If we can get your comments concisely. Thank you, sir.
Great, thank you. Brendan Marr, a Media Lab alum and computer scientist. I wanted to address a few things. I wanted to say that it is great that the Secretary of State is here and that they could offer, that they can do this for free. The napkin math shows that at $100 a pop, with 5 large entities making these things, basically they've made $500. What I'll put forth is a much more profitable thing for the committee to consider. But I want to say first off that, this could actually be, completely horrible, or can be like pretty good. Okay. And it really depends on the intent and how it's actually rolled out. And it gets to the larger question of really, what is this about? And it is the question, and it was raised here, is this really about IP registration, which is voluntary, or is it really about mandatory registration because there's going to be some, breach of some, the statute and some, criminal or civil intent? Okay, so these things are the defining part. I concur with what's been said regarding Mr. Kauffman's statement about it just being not tenable, and the other fellow who was speaking in terms of registration in some ways. But what I want to say is that on the other hand, it actually can be very good. So here's what I'm going to propose. We could talk further about this. I don't want to belabor in my short time here, but the idea is that for the Secretary of State to actually make something profitable, really what we're talking about is the more general idea of IP registration. Mr. Grossman, in our discussions yesterday and all that's being done with cryptographic signing and whatnot, with registry of entities, et cetera, dovetails right into all of that. So this is an area that we can really think about more broadly, looking to build out, because what we're talking about here is really about IP registration. The other thing, which I think is a tremendous opportunity for the state of Wyoming, is not just the registration of models, which is really ill-defined, but what is of great benefit, or would be of great benefit, is the idea of a data trust, where a data trust would allow the trust which holds the models to be able to specify how those models are used through governance of the trust and whatnot. We can talk much further about all this, but that is a much more profitable route for the state of Wyoming, because there'll be many more of those that will be registered, and it really gets to the heart of what is the matter here, which is governance and disclosure, and that fundamentally is what data trusts are about. And I'm sure Daza will speak much more about this. A lot of these ideas, early ideas about David trusts have come out of Sandy Pentland's group at the Media Lab at MIT. So he's very familiar with that. And I think the time is now to consider these things, and we can talk further about this, but I did not get into the reasons of why this is untenable as is in terms of registration, what that is, whether it's a static model or it's running in the cloud or it's distributed, all those issues. We'll save that for a later time, but there's lots of issues there. I'll take questions, or actually I'm out of time, so maybe after the break then.
Thank you, Mr. Marr. Any very quick questions ahead of our 12 break time? All right, seeing none. Thank you, Mr. Marr. Yes. Okay, thank you, Mr. Marr. Let's, Ms. Barco, if you're out there and anyone that's out there, we will be picking this back up at 1:30 when we come back in. Can you give me a thumbs up if that's okay for you to weigh in at that point in time? I think all good. All right, great. So we will start back up at 1:30 and we are adjourned for lunch.